As a matter of pending business, the chair now lays out Senate Bill 15, Senator King's bill that the chair laid out regarding records and police records and the discussion we had, Senate Bill 15. Senator Hall, I'm sorry, we're on Senate Bill 15, and Senator Betancourt moves that Senate Bill 15 be reported favorably to the full Senate with the recommendation that it do pass and be printed. Senate Bill 15, will the clerk call the roll?
Betancourt?
Yes.
Birdwell?
Aye.
Hall? Hinojosa?
Aye.
Middleton?
Aye.
Parker?
Aye.
Perry? Schwartner?
Aye.
Zaffarini? Paxton?
Aye.
Hughes?
Yes. There being 8 ayes and 1 nay, and knowing the final tally will reflect motions in writing, Senate Bill 15 will be reported favorably to the full Senate.
Senator King, you're recognized for a motion to suspend the regular order of business on Senate Bill 15.
Thank you, Mr. President. Members, Senate Bill 15 is basically the same bill we passed out in the regular session, and then again in the first call special session dealing with police personnel files. Right now, there is no consistency among law enforcement agencies regarding what files are made public and what files are not made public. This bill would require each law enforcement agency in the state to have 2 basic files for their officers. One is a personnel file and one is a department file. The personnel file would contain substantiated misconduct complaints. Those are complaints that resulted in disciplinary action, commendations, congratulations, or an award bestowed to the officer, and periodic evaluations of the officer by a supervisor. This file would be public. All other documents not required to be held in the peace officer's personnel file would be held in their departmental file. For the purposes of most of the discussion we've had on this, that would include unsubstantiated misconduct complaints against an officer, complaints that did not result in disciplinary action. All of your Section 143 cities, which I think there's 70 in the state, and it's most of all your large cities in the state: Houston, Austin, San Antonio, El Paso, Fort Worth, and I think the number is 70 altogether. They already follow this system. This came out of the sunset process 2 years ago, directed TCOL to try to find a model policy. They adopted basically the policy in the local government code for civil service cities, and this legislation simply codifies the model policy now in place by TCOL. And with that, would move suspension of the regular order of business.
Senator Eckhart, for what purpose?
To ask questions of the author.
Senator King, do you yield?
Certainly.
Thank you so much, Senator King. And in our last special session, which, wow, just seemed like it was a few minutes ago, on Senate Bill 14, you and I had a conversation in which you clarified that this bill does not affect current or future meet and confer agreements. That's still the case with this legislation, correct?
Yes, in fact, those meet and confer agreements come under Section 143 of the local government code. Austin, of course, is a civil service city under that code. And Section 143.037 actually states, with regard to, it says this section deals with agreement, meaning meet and confer agreements, supersedes conflicting provisions. And 143.307B says an agreement under this subchapter preempts any contrary statute. So 143 itself says that those meet and confer agreements preempt any other conflicting statutes. And of course, what we're doing here is amending the occupations code, not the local government code. So yes, by the local government code as it stands today, this bill could in no way supersede anything in any 143 meet and confer agreement.
Thank you very much for clarifying that. And Mr. President, I move that the remarks between the senator and myself on Senate Bill 15, be reduced to writing and printed in the Senate Journal.
Any objection? Hearing none, so ordered. Senator Gutierrez, for what purpose?
Just a few questions, Mr. President. Well, maybe more than a few. I don't know.
Senator King, do you yield?
Certainly.
Thank you, Senator. I'm a little bit confused as to what it is we're trying to seal. Is it just the records, disciplinary records, or is it documents relating to any document that is related to an incident with that particular officer?
So, again, there'd be 2 files for each officer. One is available to the public by an open records request, freedom of information request. The other is not. Now, all their records are available in a lawsuit in discovery as part of an ongoing criminal investigation, if there's an investigation into the officer's conduct by a prosecuting authority. But the file that would be available to the public would have, it's called the personnel file. It would have all substantiated misconduct complaints. It would contain all commendations and awards that an officer has received, and all periodic evaluations by a supervisor of the officer. And in most of your civil service cities, those are required, I believe, by statute every 6 months. Every other document, their background investigation, their for employment, their home address, their personal information, unsubstantiated misconduct complaints against an officer, complaints that were shown to be unfounded, coaching documents by a supervisor, anything else would be in that department file, which is not available to be disclosed through an open records request. Usually those requests come from media, from organizations that are fishing for information on an officer.
Why would they be fishing for information?
Well, to be honest, a lot of them come from very left-wing organizations, progressive organizations that are just trying to, that are very opposed to law enforcement. Others come from media that are trying to follow up and get other information as to maybe an incident, an allegation that arose. Or it can just be just any member of the public that wants to know what might be in an officer's file with regard to any incident that occurred, or maybe they just want to see everything they can about that particular officer.
You and I are subject to open records requests, are we not? Our emails, correct?
Well, there are limits to those.
Right. But you and I are subject to
Such as things that are done and that are legislatively protected, that are part of our legislative process.
I guess what I'm trying to get at is, and I'm not trying to poke the bear here. I'm not trying to get argumentative with you just for the sake of being argumentative. I know that sometimes I can do that. I'm just trying to find, just looking for why the justification for all this, because don't we want transparency?
So there are, the Open Records Act has limits in it that we're subject to, that everybody is subject to, open records request limitations. And I guess I used this example last week, so I hate to use it again, but it's one that I ran into when my very first training officer, when I was a young police officer. And I never will forget that training officer told me, the first week we were together, he said, "Son," he said, "you never get fired around here for doing too little. You get fired for doing too much." And typically what you find with officers, the ones that are really working hard, really pushing hard, really trying to do a good job, and are out there aggressively trying to do law enforcement, they tend to get more complaints against them. Sometimes those are from defendants that have been arrested, and it's a way of trying to deflect that arrest and to try to show that the officer, or allege the officer was doing something, as a way of trying to get to a plea bargain or get charges dismissed. Other times it's just because the more you're out there. I can remember one occasion, I mentioned this last week too, when I was sent to go out to deal with a prominent group of citizens' kids, and I told the supervisor, I said, "Look, I'm happy to do this, but I know what's going to happen. As soon as I go take that action against them, then there's going to be a lot of prominent citizens coming down, and they're going to file complaints on me because I did something to their children, because I wrote them tickets, I arrested them." And I said, all I want to know is that you're going to back me up when those complaints come in. That's what officers run into. So there are a lot of unsubstantiated complaints. And what happens is when someone gets access to those, and if an officer has had 4 or 5 unsubstantiated complaints over the last 10 or 12 or 15 years, then all of a sudden those end up on Facebook and in the media. And it's embarrassing to the officer. It's embarrassing to their family. It's humiliating to the people they know. And those are things that were never substantiated because they weren't true.
What
And
about the
that's what we're
substantiated
trying to keep
complaints?
out of the open records. If an officer did something wrong, if they were disciplined, that needs to be made public to whoever wants it.
Well, but what if the complaint is issued? For instance, in San Antonio, the cop who was accused of later found out to be true of making a homeless man eat what was called a shit sandwich. He grabbed a piece of bread and he put dog feces in the sandwich and he gave it to the homeless man, said, eat it. Under this happened. You could look at it in the newspapers, on TV. He was fired, then he got his job back somehow because the police officers union stepped in, said, oh, well, we're going to send him to some classes. He did some classes. He's back on the police force because of all those union protections that we all know. But it was 100% proven that this happened. And so when the person makes their complaint under this bill, no one would ever see that Matthew Lockhart, or whatever his name was, gave this person a shit sandwich because he's protected under your bill. That's not a good cop. Well, let me ask you this.
Well, let me
that wouldn't be a good cop, would it?
You said that completely wrong. Please let me correct you if I may right now. In that case, that officer was disciplined. In fact, they were terminated. They apparently went through a civil service appeal process, got put back on, but they still had a formal disciplinary action taken against them. And all the information related to that disciplinary action would be made available to the public.
I'm speaking of before.
Under this bill.
I'm speaking of before, when the complaint is made, until you get to that process, and while we're waiting the pendency of that process, all of that material sealed. Is that not correct?
Well, disciplinary actions usually go pretty quickly, but yes, while it was under investigation, it would be classified as unfounded. But as soon as the discipline took place, which in this case it obviously did, then it's made available to the public, to anybody who wants it. In fact, that's how you found out about it.
Yeah, I found out when the complaint was made because it went to the media. The media got their open records request because they were able to do so. They found that the complaint was made and the allegation was made, and then that is what actually drove the investigation, which then was proven by testimony of other cops to be true. Matthew, it's not Lockhart, it's Lock something. He's not a very good cop for doing that, is he?
No, it sounds like he was terminated for good cause.
Sadly, unfortunately, he's now back on the force. But that happened.
But it's public.
Under your bill, it wouldn't be public until the investigation and the disciplinary action is done.
I suspect even without this bill, it would not be public until the disciplinary action was taken.
Well, it was public. It was made public. That's what I'm trying to tell you. Under this bill, we wouldn't hear anything about this other than the accusation, but for the fact that we would have to wait for the investigation to be finished and the disciplinary action to be complete. So let me go back. That's the shit sandwich story. Let me go back and talk about what I'm most concerned with in this piece of legislation. You had this bill come out in the regular session, correct?
Yes.
And somehow it just didn't pass muster.
Point of order in the House.
Point of order. Got it. You had said during your deliberations, your comments on the Senate floor, that you weren't, when you were asked by someone, well, what are we trying to seal? You said any document, because your office didn't know what documents might not to be sealed, so that they are just sealing them all. So any document?
No, I'm sorry. I'm sorry if I haven't been clear in that. Let me walk through it again. There'll be 2 personnel files, and this is what San Antonio already operates under today because they are a Section 143 city. So San Antonio is already under this exact policy. But what San Antonio has and what every law enforcement agency would have is 2 personnel files. The first one is called a personnel file, and it is available by open records request, and it would have all substantiated misconduct complaints, all commendations, congratulations, or awards bestowed on an officer, the periodic performance evaluations of the officer by a supervisor. All other documents of any nature would be in what is called the department file, and that is not available for general disclosure to the public. It is available in lawsuits. It is available by prosecuting attorneys. It is available if there's a criminal investigation against the officer or anything of that nature.
You are
and it's
familiar.
certainly available under Michael Morton and Sandra Bland Act and things of that nature.
You are familiar that the fact that the Texas Department of Public Safety was sued by the families of Uvalde. You're further familiar with the fact that DPS was sued by members of the media in an attempt to get all of the records and body camera footage and everything else that went on during that horrible incident in Uvalde. I'm sure you're familiar with that lawsuit. You realize that the state of Texas has appealed that lawsuit, that ruling of the district court judge.
So with regard to the body cameras are in a different statute. They would not be affected in any way. Those aren't part of an officer's personnel files. Those are part of a criminal investigation process. This bill would in no way affect body cameras. The statute would remain the same.
What about statements from police officers?
It would not affect statements by police officers, except
All the statements from the cops at Uvalde, it says there's an AR-15 in there, there's an AR-15, I don't want to get clapped out. Are those protected?
This bill wouldn't have anything to do with that.
Wouldn't have anything to do with that. So the media would be able to get that footage.
Well, whether the media can get that footage or not has nothing to do with this legislation.
So all of the statements that were taken from all of the police officers, the 96 DPS troopers and Texas Rangers, including Ryan Kendall, who sat there for 45 minutes on his telephone circling that room, all of those statements are not covered by your legislation. In other words, the media can get access to those particular pieces of evidence.
I'm not saying the media can or can't. I'm saying those are part of a criminal investigation process. They're also part of civil suits. They're part of, I think they're certainly part of civil suits. I don't know if there's any criminal charges still ongoing with regard to that. But this legislation would have no impact on that in any way. If an officer was disciplined for what took place at Uvalde, the fact that he was disciplined, the penalty that he received, and the conduct that he was disciplined for would be part of his file that is available to the general public. But any statements he made or she made in any incident, those are going to be governed by the rules that already apply to criminal investigation process.
And therein lies a second problem. I'm glad you're answering my stuff for me. Ryan Kendall was disciplined, and then when the DA didn't, this Texas Ranger that stood around doing nothing outside the room, and the other 12 people, I'm out, let me finish, I've let you finish. So he was disciplined. Then the district attorney says, oh, we're going to prosecute these 2 local cops, and all the DPS troopers and all the Texas Rangers were let off the hook. And so none of those, so he gets his job back. Ryan Kendall then gets his job back. Steve McCraw says, King's X, you're good, you're fine, you're going to get your job back. And so the general public really has no way of ever seeing the biggest failure in Texas law enforcement history. No way of seeing any of that under your piece of legislation. Those families will never, ever get the relief and the accountability they deserve from this state.
Respectfully, the DPS is not currently under a policy like this. Now, that said, had they been, or if they become so, if an officer from Uvalde or any situation is disciplined for a violation of conduct, then that is available to the public. It's only unsubstantiated disciplinary complaints that are protected. And they are protected because they are unsubstantiated. They were not proven.
Senator, I signed an NDA agreement. I can talk on this floor all I want about what I saw. I get legislative privilege. You know that. Cops pontificated outside that room. DPS troopers are, my God, this happens in America all the time. This is horrible. Instead of doing their jobs, cops said there's an AR-15, there's an AR-15. Cops said, DPS troopers said, I don't want to get clapped out today. I don't want to die. You would never, when you were a cop, you would have never said anything like that. But under your piece of legislation, that, what I call bad conduct, and I assure you, you could look at all the body cams and you can see what they said. Under your piece of legislation, if they're not sanctioned, if they're not disciplined, no one will ever see that. No one will ever see that great, horrendous, and tragic failure of the Department of Public Safety.
That is, I'm sorry, but that's an incorrect statement.
Well, tell us, elucidate.
Okay. Again.
I don't mean through a lawsuit.
No, I'm not. So the disclosures we're talking about here are disclosures that would be made available through the Open Records Act through a Freedom of Information request. If there is a criminal investigation, if an officer is under criminal investigation, if there is a lawsuit ongoing, the discovery process, all of the officer's records, personnel file and department file, all those are available through discovery. This bill doesn't affect that. If there is a criminal investigation ongoing against the officer, all of that is available. Michael Morton, Sandra Bland Act, all that still applies. All this is talking about is when someone files an open records request and says, I would like to see the police files of Officer Joan Smith, then what will be released is the personnel file that has sustained disciplinary actions against the officer, their commendations, and their periodic performance reviews. That is what would be released to the public on an open records request.
There is a lawsuit pending. The Attorney General is defending the Department of Public Safety, and that lawsuit, it was done by the media. Hell, I sued the state of Texas and couldn't get the documents. And so they said, Senator, we'll let you see everything. You just got to sign this non-disclosure agreement. There is a lawsuit pending. And nobody in the media has been able to see that. The families have been able to see nothing. The local cops, they submitted everything. The local school district police submitted everything pursuant to the ruling of that judge in that law court. Your colleague on the other side of the building, Don McLaughlin, said, what do we have to hide here? They all failed. And yet you're telling me that, hey, we can see this subject to some lawsuit, and yet we have not been able to see anything. But that's not my point. You shouldn't have to file a lawsuit because we have an Open Records Act. And you want us to sit here and pass this piece of legislation because you're saying you don't want cops to be defamed by some false report. And what I'm saying is, don't we want the truth over everything all the time? And isn't the truth more valuable than the potentiality for some cop to be defamed by some unsubstantiated report?
Well, it's much more than a potentiality. It happens all the time. That said, and you said it yourself, nothing was good about the way Uvalde was handled by law enforcement. Nothing was good.
And shouldn't we know? Shouldn't the public know what happened?
And I'm not saying they shouldn't. I'm just saying that that information has nothing to do with this legislation. This if there are, I'm assuming what you're telling me is that there were open records requests made and there's lawsuits about that. But I also know that there's ongoing lawsuits, and all that information is available to the parties, to the families' attorneys through that discovery process. And it's out there, so somebody knows about it.
It actually
if any of those officers are disciplined, I don't know what officers at DPS were disciplined or were not disciplined. But if they were disciplined, It would be made available to the public under this legislation.
You're a much smarter lawyer than me. I don't know, but I know that there is lawsuits pending, and I know that the family's lawsuits are pending, and none of them have gotten to see the body cam footage, the police reports, the police statements. They have begged me to show them. And I won't do it not because I signed an NDA with Ken Paxton. Who cares? I won't do it because I don't want them to see their dead kids dragged along the floor by cops. Little girl without a face. They failed so miserably, Phil, and the people in this building have done nothing to give them accountability, and this piece of legislation makes it that much harder for them to ever have any accountability.
I have been at the scene of more shootings and stabbings and sexual assaults than I can actually remember. I've been there when officers are laying on the ground bleeding. I've been there when officers are laying on the ground dead. I have never been to anything that would come anywhere close to what people endured and saw and witnessed in Uvalde. But what I'm trying to tell you is that this legislation doesn't change any of that. What this legislation says is where there are unfounded, because that's what this is really all about, where there are unfounded complaints made against an officer who's just trying to do their job, that those unfounded complaints will not be made public. And that's really what this comes down to.
Well, I'll tell you what. There's no one, for as many bad jokes as you and I have heard about lawyers, and you and I have done a lot of criminal defense on both sides. And you see a lot of horrible stuff. Criminal defense judges that prosecute these cases, like Senator Huffman, has seen the most egregious and horrible stuff, the most egregious murders, children being molested, and photos of those horrible, horrible acts. Senator Hinojosa as a trial lawyer, Senator West as a defense lawyer, we've seen all of those things. You're right. I've never, ever seen anything in my 27 years of practicing like what I've seen in those hundreds and hundreds of hours of body cam footage. And I won't show it to those families. But your argument that those things are available to them is really wrong, because it has not been made available to them or to their lawyers. And so if your bill is not about that, if your bill is about something else, then I want you to not just agree with me, but co-author this amendment that I have, so that those families in Uvalde and other victims like them will be able to see this kind of reports and body cam footage immediately. We'll talk about that when that amendment comes up. We don't need to belabor this point. But the reality is, and I disagree with you, I think that the public, that every law enforcement agency in this state should be 110% transparent. I would think that every cop would want to be transparent about what goes on in his department, his or her department. I would think that every cop in this state would say that that officer that made some homeless guy eat a shit sandwich should never, ever serve on any police force ever again. So shortly, you'll have an amendment from me, and we'll talk about that. And if you want, those families deserve to have the accountability, and they deserve to see these documents. Thank you, Mr. President.
Senator Cook, for what purpose?
To ask questions of the author.
Senator King, do you yield?
Certainly.
Before I begin, I actually would love to move to have the conversation between Senator King and Senator Gutierrez reduced to writing and placed in the journal. Can I do that now?
Yes, you can do that now. Members, with no objection, hearing none, so ordered. Senator Birdwell, for what purpose?
Parliamentary inquiry.
State your inquiry.
If the journal is printed, does it have to include the foul words used in the conversation between Senator King and Senator Gutierrez?
Senator Birdwell, this presents a new question that we're not sure of.
Would you like me to come forward?
Could you come forward? Senator Cook, for what purpose?
Keep going to ask the author some questions. Thank you, Mr. President.
Senator King, do you yield?
Yes, of course.
Thank you, Senator. So it's my understanding that the word document, as it pertains to the language in your bill, is actually not well defined in statute, and it's been held previously that that does include body cam footage. Are you advised on that at all?
Yes, so body cameras are in a different statute. Body cameras are not part of an officer's file. They're owned by the department, by the law enforcement agency. They're part of their criminal investigation process, and so this bill doesn't have any impact on body cameras. It's a whole different statute.
Well, this bill is dealing with everything that's not the personnel file, so right, but it is a document relating to a licensee, correct? That's really broad.
Well, what it's dealing with are personnel files, an officer's file. From the hospital, at the hospital, you have hospital files on all the employees. And, but I'm sure that the security footage that's filmed in the building isn't put in anyone's personnel file because it's not part of a personnel file.
But we're not talking about personnel files, we're talking about department files. Personnel files already exist, right? And they don't have the unsubstantiated claims in them, et cetera. It's the department file that could contain body cam footage because it's a document relating to a licensee, right?
Okay, all I can tell you is there's a separate statute, and I can pull it up, I've got it in the notes here, but there's a completely different separate statute on body cameras, that body cameras are not considered part of an officer's file. Their personnel file, the department file, any file. They are something owned by the department, just like the vehicle that the officer drives is owned by the department, not by the officer that's driving it. The footage that video takes in is owned by the law enforcement agency, not by the officer. It's not part of anything at all that this bill deals with.
I'm confused because that feels like exactly what we're all concerned about. So C says a department file must contain any, big old word, any letter, memorandum, or document relating to the license holder that's not included in a personnel file. That sure seems like it also includes body cam footage, 911 transcripts, potential logs.
So body cam footage, 911 transcripts, those are not documents that are in any way part of a law enforcement officer's personnel file.
But your bill entirely deals in the content area of things that are not in the personnel file, right?
So, and you're from Houston, and Houston already uses this process.
They don't use SB 15, they use Chapter 143.
I'm sorry, could you say that again?
They don't use a bill that hasn't passed, they use Chapter 143. It's just not have a department file, right?
Great. Chapter 43 that the city of Houston is under today already divides the Houston Police Department's personnel files on an officer into a personnel file and a department file. This essentially codifies that for the entire state, the same thing that Houston is under today. Body cameras footage is not a document. It's not something that this bill in any way affects.
So I know for sure that SB 15 would change the way that Houston operates because we talked about this last time. KHOU broke the story about head strikes in Harris County jails. The same way that the San Antonio Express also broke a story about use of force, and they used the exact information that's going to get socked away and hidden in the department file. they used exactly all that information to show a pattern that led to changes in how law enforcement in Houston operates, or in Harris County. So it's not like we're just going from chapter 143 to chapter 143, right? We're going from chapter 143 to a whole new method where a department file that's any document relating to a licensee, super broad, is completely sealed from even us, right?
So we're talking about the Freedom of Information Act request for open records request. We're not talking about a criminal investigation. Mm-hmm. We're not talking about a discovery process in a lawsuit. Every police officer has an HR file. Mm-hmm. For all the civil service cities, including Houston, and for all police departments, if this legislation passes, everyone will be under what is the new TCO model policy that's recommended. It divides that officer's HR files into two separate files, one of which is available to the public mm-hmm. through open records requests. The other is not. Mm-hmm. The one that is has their disciplinary records if they've been disciplined for any action.
Right.
It has their commendations, all the good stuff they did, and it has their performance reviews. Anything else that would be in an HR type file, their pay grade, their background investigation, their test scores probably from when they were in the academy, any other records that they have of an HR nature would be in the department file, which is not available through open records request. Now, if you sue that officer, you can get all that stuff through discovery. If the DA is investigating that officer, they can get all that through discovery, through that process. A criminal defense attorney could as well, under most circumstances, I guess. But body cameras and things like that have nothing to do with an HR file.
Okay, and just to be clear, Chapter 143 is not prescriptive in what should go into a department file, and it actually says that they may have a department file. You shall have a personnel file that says all the stuff that you've been saying. They may have a department file, and then there's nothing about what should or should not go into that. So this is a big change. SB 15 is certainly not just standardizing 143, right? It's a big change.
I think it's going to be virtually the same for the 143 cities like Houston. However, Houston, like Austin, has a meet and confer agreement that they operate under. And those meet and confer agreements, like in Austin, can have their own records HR system prescribed within that meet and confer agreement. I suspect that Houston does. I'm not for sure, but I bet it does. And those meet and confer agreements will supersede anything about this statute.
Okay, cool. Well, it's my understanding that it's been held many, many times that the word document includes digital and can include body cams. I feel like I've just seen that a lot before. I'm going to propose an amendment. I've got more questions for you, but I've got to propose an amendment that basically says that Chapter 143 should supersede this policy as well, if that's what since the voters voted for that. So since we're looking for consistency, I just hope you'll consider that amendment, because I hear you talking a lot about consistency. So as a nurse, I'm expected to adhere to rules and statutes governing my profession, and doing so is obviously in the best interest of my patients, right? And like nurses, police work can be a matter of life and death. Are you familiar at all with the rules that govern nurse personnel files, disclosure, and complaints?
No, I'm not.
Okay. I got a memo here for us, so just so folks know, employers with 8 or more nurses on staff are required by statute to form peer review committees for incident-based dispute resolution. In the case of peer review committees, only the contents of the process are strictly confidential. However, the law provides for the committee to make available written oral communications to licensing authorities of any state, law enforcement agency investigating a criminal matter, another peer review committee, or state or federal accrediting organizations. Disclosures are meant to protect, to the extent possible, the identity of patients. So I do know actually when cameras footage has been used, but you can't use anything that violates HIPAA. And hospital personnel files, the Texas Board of Nursing regularly receives these, either by request or subpoena, the hospital personnel files of nurses. Nothing in statute or rulemaking allows or directs employers to conceal unfounded investigations. We spoke with the general counsel of the Texas Board of Nursing, and they said these files are actually critical to Board of Nursing investigations and are essential to establishing fact patterns in the aggregate. So we've all got confidential stuff. We all have to be safe. Everybody, there's always unsubstantiated claims against people who are doing good work, but why does law enforcement deserve more protection than healthcare workers?
Again, I think that's what this bill is all about. Law enforcement are in a very unique position. And I may be wrong in nursing, but I don't see nursing having to have internal affairs departments just to manage investigations of complaints against officers. And I don't really know how to answer that question, but I'm just saying that there is a very serious problem. That's why the law enforcement community for multiple sessions has been trying to get this type of legislation. Finally, in the Sunset Commission bill 2 years ago, we asked as a body TCOL to come up with a model policy. They looked around the state, had a long work group work on it during the interim. They looked and saw what was in 143 and said, that's the best we've seen. They framed the model policy to essentially be what's in 143 today. And we would be adopting that through this legislation as the requirement for all law enforcement agencies. And I understand you peel all the layers away, what people are worried about or concerned about is should unsubstantiated complaints against a law enforcement officer be made available to the public through an open records request. And I will just tell you that abuses I've seen of that and that law enforcement endures tells me they should not. I understand that everybody doesn't feel that way, and that's why we have to vote on that on the floor.
Yeah. And I mean, just from the two big things off the top of my head, the San Antonio Express and the KHOU investigations, do you think that the suffering of an law enforcement officer who's just receiving a bunch of complaints does that compare to the pain and suffering of folks in jail who are getting lethal force when it wasn't needed?
I just really feel like we're getting off the subject matter here.
Yeah.
And I feel like I've answered about everything I could think to answer.
Yeah.
This really comes down to, do you agree or not that unsubstantiated complaints against a law enforcement officer should be available to the media and everybody else? If you do, then vote for the legislation. If not, then I would then vote against it. But I don't know how to answer anymore. I don't know what else to say.
Yeah, I guess under your bill, it seems like even like TCJS would not be able to get a hold of any of this information, right? Can't share it with other agencies, no Public Information Act. It's just completely sealed unless there is a lawsuit or criminal investigation, right? So even if another agency is looking for patterns.
I'm trying to envision a circumstance where a jail standards commission or something like that is wanting to look at complaints filed against a police officer or a sheriff's deputy somewhere. I don't know how to answer that.
In instance of deaths or escapes, they'll ask about ongoing disciplinary action. And
if they're applying for a job with another law enforcement agency, that law enforcement agency would have complete access under statute to all the officers' records from wherever they've been employed before.
Yeah. So for specifically escapes, CCJS will typically request photos and video footage, criminal history reports, hourly check logs, any additional relevant reports, whether any officer discipline is pending, and they also note that usually they only ask for some of these other documents that would likely be covered by SB 15 if they're worried about obfuscation. If they're worried that something's not adding up, then they go and ask for more documents to show the whole picture and understand a pattern. And I'm concerned that our own agencies are not even going to be able to get a hold of the information that they need if this passes.
So if a law enforcement agency wants to know, so are you talking about an employment process where someone's applying for a job with another law enforcement agency, maybe a jail standards commission or TDCJ or something?
They've already been hired and they're working there now, but
So if someone is a law enforcement officer or has been, and they are applying for a job with another agency, that agency is actually required by law to get all the records from the prior agency and review those.
no, I'm so sorry. This is,
TCOL also has the authority to do that. If TCOL has a license investigation going into any law enforcement officer or former law enforcement officer, they have the authority to get those records as well. So none of that is protected by this statute.
okay. Okay. Well, I appreciate you taking my questions. I'm confused on how, I remain confused on how any document doesn't include body cam footage.
Because the statute, there's a separate statute on body cameras, and they're not part of a officer's HR file, and they're not a document.
Not a document. Okay. One more thought, just because I know some of the agencies out here are not as large as others, like those in Houston, San Antonio. Under your bill, is it possible that a constable accused of some kind of misconduct would simply look at his or own conduct, because there are places where there's like single person agencies, right? Find nothing wrong and put everything related to the accusation into the sealed file. Is there anything in your bill to prohibit that from happening?
So there's something like 1,700 law enforcement agencies in Texas, and it's something like, I'm sure I'm way off on the numbers, but I think it's something like 70% of those have 10 or less officers. My thought is you want some structure that says what they are to keep in their HR files, in their personnel files, and this provides that structure, and then so everybody knows what they're supposed to be keeping. You're quite right. There are probably law enforcement agencies out there that basically have no files other than the minimal amount that TCO might require them to keep. And to me, I think that this puts a model policy in place that every law enforcement agency is going to have to follow, and everybody will know what all the rules are.
Okay, and I just want to say one more time, the bill is specifically talking about content not included in a personnel file. We are not talking about the personnel file. We are talking about a department file. It's everything else, right?
And let me go back to calling it an HR file. Every law enforcement agency keeps HR records on their employees, on their officers. This will require them to have that to be bifurcated into two different files. One is called a personnel file. The other is called the department file. The personnel file will have those three things in it I've mentioned repeatedly. Everything else is in the department file.
Yeah. Okay.
Whatever it may be.
Okay, awesome. Well, I really appreciate you taking my questions, and I hear you on the consistency with Chapter 143, so I'm hopeful for the amendment in a little bit, but we'll see. Thank you.
Senator Huffman, for what purpose?
Question the author briefly.
Senator King, do you yield?
Certainly.
Briefly. A couple of questions, and I rise because it feels like the issue's gotten a little muddled here. I think we're all a little tired. But I want it, because it's very important, it was an important piece of legislation in 2021, SB 24, that I authored that was widely bipartisan support and widely supported by law enforcement throughout the state. And that once and for all kind of cleaned up the hiring practices and put, a burden on those hiring police officers from other agencies to thoroughly review personnel files and records and have access to everything that they needed to make good hiring decisions so that, and the bad cops are few and far between, but when they're there, so they don't get passed on from agency to agency. So my question is there anything in this legislation that you propose tonight that would get rid of those reforms that we made under the Police Transparency Act in 2021?
Absolutely not. In fact, it has a statement, I think in Section F, that talks about that wherever it's required by other law, this bill doesn't apply, this legislation doesn't apply, this statute doesn't apply. And just like with the Sandra Bland Act and the Michael Morton Act and the body camera statutes and the requirements that law enforcement agencies have access to and review, and that was a big piece of legislation because people were passing bad officers along.
Right.
And they weren't being able to get access to files from where this, and so where if someone's applying with another agency, all that officer's files from their previous agencies are made available because of the very good legislation you did in 2021. This doesn't change that at all, nor does it change the requirement that a new agency thinking about hiring somebody check all those records before they hire them.
Right, and they have to verify and conform that they did, and if they don't, that's a violation in itself by the lead law enforcement head of the law enforcement agency, as I recall, correct?
This changes none of that good law.
Okay, I just wanted to verify that. Again, there's been a lot of discussions back and forth, so thank you
It
very
has
much
gotten
for
muddled,
answering.
and I'm pretty muddled feeling myself right now.
Yes. Thank you.
Senator King moves suspension of the regular order of business on Senate Bill 15. There is objection. Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell, Cook.
18 ayes and 12 nays. The rule is suspended. Chair lays out on second reading Senate Bill 15. The Secretary will read the caption.
Senate Bill 15 relating to certain files maintained by a law enforcement agency regarding certain employees of the agency.
Following an amendment, Secretary read the amendment.
Floor Amendment Number 1 by West.
Senator West, you recognized.
Thank you very much, Mr. Chairman. Mr. President, this amendment is agreeable with the author. He's made several mentions to the Sandra Bland Act, the Michael Morton Act, and also body cameras. What this amendment does is clarify, for purposes of accountability and transparency, the materials that in these files that fall under the Sandra Bland Act, the Michael Morton Act, must be disclosed, and that this statute does not impact the release of body-worn camera footage under the Code of Criminal Procedure.
Senator King, you recognized.
That is correct. This is a very good amendment. It simply clarifies and makes it clear in Section F, where it talks about, as required by law, that includes Sandra Bland, Michael Morton, and the statute that deals with body cameras. So it is acceptable to the author.
Questions on the adoption of floor amendment number 1 is acceptable to the author. Is there any objection? Hearing none, so ordered. Following amendment, Secretary read the amendment.
Floor Amendment Number 2 by Gutierrez.
Senator Gutierrez, you're recognized.
Thank you, Mr. President. Members, this is an amendment that says every law enforcement agency shall disclose documents contained in the department file to individuals who filed the complaint, presumably a criminal defendant, individuals who were the subject of the conduct or family members of the subject of the conduct now deceased upon completion of the criminal investigation or investigation by internal affairs unit or a supervisor. We saw what's happened in Uvalde. No family has been able to see these documents from the Department of Public Safety. The 15th Court decision over release of DPS documents to Uvalde families and the news media is imminent. After 3 years of waiting, a separate appeals court has already directed that Uvalde County and Uvalde ISD to release the records, and those governmental bodies started to release the documents just this week. DPS and the Attorney General's office have fought the release of those documents, and that's what this amendment does. It allows those families to be able to get all of those records and those documents and those body cams. Move adoption.
Senator King on the amendment.
We've already had a long discussion of this. I would oppose the amendment for the things I've already mentioned.
Questions on the adoption of floor amendment number 2? Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco, Campbell, Cook, Creighton.
The 11 ayes, 19 nays. Amendment fails. Following amendment, Secretary read the amendment.
Floor Amendment number 3 by Cook.
Senator Cook, you're recognized.
Thank you, Mr. President. The Houston, the biggest city in my district, does already have Chapter 143. It has a department file. And I understand, it's model legislation and we want consistency. I hear all of that. And so I offer this amendment that would simply allow Chapter 143 to remain the privilege statute in cities like mine that have adopted it, that the voters approved. And I just want to say, and you shared that story with me before, Senator, about no one gets punished for doing too little. They get punished for doing too much. And I hear that. And in my nursing practice, we want to hit it just right. And so if my police chief in my district wants to release documents when it's in the best interest of public health, I want him to have the flexibility to do that. And again, it is what the voters approve, so I move adoption. Thank you.
Senator King on the amendment.
Again, respectfully, I think these are things we've already discussed at length, and so I would oppose for those reasons.
Question is on the adoption of floor amendment number 3. Secretary will call the roll.
Alvarado, Bencourt, Birdwell, Blanco, Campbell.
The 11 ayes, 19 nays. Amendment fails. Senator King, you're recognized for a motion.
I move passage to engrossment.
Senator King moves passage to engrossment. There is objection. Secretary will call the roll.
Alvarado, Bencourt, Birdwell, Blanco, Campbell.
The 18 ayes, 12 nays. Bill is passed to engrossment. We will hold there, Senator.
Thank you, members.
All right, the chair lays out Senate Bill 15 by Senator King. What you looking for? That's right. All right, thank you, members, for hearing my bill today. Appreciate y'all being here on a Friday morning in a special session in August. Certain information related to a peace officer should be open to the public, and certain information should not be disclosed to the public. Unsubstantiated complaints of peace officer misconduct, in particular, should not be released to the public. Right now, there is no consistency among law enforcement agencies regarding what files are made public and what files are not made public. Civil service cities, which are those that have adopted Chapter 143 of the Local Government Code, currently maintain both a separate personnel file and a department file for every officer. Some of those cities that had the 143 adoption are cities like Tyler, Lubbock, Fort Worth, and Amarillo, and other cities around the state. Around 26,000 peace officers total operate under provisions of this bill currently. Chapter 143 requires the following documents to be held in the personnel file: substantiated misconduct complaints, which are those resulting in disciplinary action, accommodations, congratulations, or an award bestowed on the officer, and periodic evaluations of the officer by a supervisor. All other documents not required to be held in a peace officer's personnel file must be held in their department file. This file would include unsubstantiated misconduct complaints against an officer, coaching documents, and background hiring information. Other law enforcement agencies would still have access to this file for the hiring purposes. In response to a recommendation by the Sunset Commission, Cole commissioners adopted a model personnel department file policy for all law enforcement agencies that substantively mirrors the requirements of Chapter 143 for civil service cities. Senate Bill 17 codifies this model policy to prevent any conflict with current law. I do want to stress that Senate Bill 15 not only that it only affects requests for disclosure under the Public Information Act. If someone is suing a law enforcement agency or officer, They will still have access to the documents in the department file via discovery as required by law. This is true for a prosecuting attorney attempting to access files to press criminal charges against an officer, defense counsel, and other policy agencies. Additionally, this bill will not affect disclosure requirements under the Michael Morton Act and the Sandra Bland Act. Senator King accepted an amendment on the Senate floor that clarifies for purposes of accountability and transparency of those specific acts. Members, the reason for this bill is to make sure that we maintain transparency, but that we don't weaponize this department file in cases to discredit our officers. That is something that we're seeing around the state. These things that should not be used to discredit them are being used. And so we want to protect the integrity and transparency of the process, but also help our law enforcement officers do their job. So with that, I'm happy to answer any questions. Show Representative Pearson present. Chair recognizes Representative Pearson.
Thank you, Chairman. Only have one question. As of right now, does this include all police departments, or are there any police departments that are not included?
It would include all police departments,
Okay.
all agencies across the state.
Okay, thank you.
Chair recognizes Representative DeRazio.
Thank you, Mr. Chairman. I have two questions. Question number one, would the passage of this bill in any way prevent the release of video footage, either from body cams or security cameras, when it comes to investigations?
No, this bill doesn't affect the body cam process at all. That is policed and managed, and it's in its own section of code. We're not touching that.
Okay, thank you. And question two, would the passage of this bill change anything relating to internal investigations of small law enforcement agencies?
No, sir.
Thank you,
It
Mr.
would not.
Chairman.
Did you have a question?
I just wanted to clarify, thank you, Mr. Chairman. It's not just police departments, also sheriff's departments,
Correct.
any law enforcement
Yes.
agency. Okay, thank you.
I think you've
Correct.
answered my question. I mean, my deal is, you know, being, was a mayor of Uvalde during the Robb School deal. We're 3.5 years. You saw yesterday the school district didn't release all the information they had. I want to protect our officers, and I see the intent of this bill. I just want to make sure that files like that aren't used, or this law isn't used to hide those files. I mean, I still think we need answers to that day.
Right, and this bill would not affect those cases in any way. And so that's a legal process, and there's a process working its way through there that this would not affect in any way.
Thank you.
All right, if there's no other questions, we'll proceed to testimony. Chair calls Sarah Beck. Sarah Beck, B-E-C-K. Okay, we have Sarah Beck registered, testifying on behalf of herself against the bill, but not testifying. Chair calls, is it Lakshmi Fox? I apologize if I didn't get that pronunciation right. Did I pronounce it right?
Lakshmi. It's close
Lakshmi?
enough.
So you registered as Lakshmi Fox, testifying on behalf of yourself?
Yes.
And against the bill, is that correct?
That is correct.
All righty, please proceed.
Good morning, members of the committee. Thank you for your time. My name is Lakshmi Fox. I am here to oppose SB 15 as it fails small agencies and hides misconduct. SB 15 would require all law enforcement agencies, even those with just one officer, to maintain a confidential department file that includes misconduct allegations. While this sounds like accountability, it actually enables secrecy, especially in Texas' smallest departments. According to TCOL, 44.4 of agencies, that's 1,227 total, have 5 or fewer peace officers. 542 of those agencies have only 1 officer, and 331 of those are elected constables. This bill would force single officer agencies to file and seal misconduct records about themselves with no oversight. The key problems with SB 15 is one of them is self-surveillance. One-person agencies would be responsible for documenting and sealing complaints against themselves, and there's no meaningful accountability in that. This would also shield elected officials. Constables and sheriffs could bury their own misconduct in confidential files. Without any amendments, even public integrity investigators or jail standards officials cannot access these records. Blocks transparency and oversight. Civilian oversight boards and other agencies would be shut out. Instead of exposing misconduct, SB 15 helps hide it. It silences whistleblowers. In small departments, reporting a colleague or a boss is already risky. Knowing the report will be sealed and controlled by the accused only discourages speaking up. The bottom line is that SB 15 creates a system that protects bad actors, especially in the 44.4 departments that are too small to self-police. It sacrifices transparency and public trust in the very places where oversight is the weakest. Please oppose SB 15. It doesn't fix the problem. It hides it. Thank you.
Thank you, members. Any questions for this witness? Thank you for being here. We appreciate your testimony.
Thank you.
Chair calls C.J. Grisham. I have you registered as C.J. Grisham, testifying on behalf of yourself and against the bill. Is that correct?
That is correct. Yes, Mr.
Okay,
Chair.
go ahead.
And hello to my awesome Representative Hicklin. You represent us well, man. My name is C.J. Grisham. I'm here in opposition to SB 15 on my own behalf because as a civil rights attorney at the website isuebadcops.com, SB 15 is perhaps one of the most dangerous bills I've seen since I began coming to the Capitol. SB 15 should be named the Protect Bad Cops and Let the People Eat Cake Act. I feel like this body needs to be reminded that Article 1, Section 2 of our Constitution says that all political power is inherent in the people and that all governments are founded on their authority and instituted for their benefit, not the benefit of protecting bad cops, the people's benefit. Mr. Chairman is correct that there is currently no consistency regarding law enforcement records. That's because some departments believe in transparency and some don't. Unfortunately, most don't, in my experience. It's that we investigated ourselves and found no wrongdoing mentality. SB 15 creates a department file where any file maintained by a law enforcement agency is protected from release that includes findings of no misconduct. Here's the issue that I have. Because, Mr. Chair, you correctly laid out the bill and said that I can get this information through discovery, right? But guess what that means? That means that someone who's been wronged, before they file a lawsuit, they're not going to know whether they have standing or not. And they're going to have to hire and pay an attorney to get information that they should be able to just get. A good police officer isn't afraid of having unfounded complaints released. It actually makes them look good that they've got unfounded complaints. A bad police officer does care, and I'll tell you why, because there's something called Monell liability, and I don't know how many people here are attorneys, but in order for me to sue under Monell liability, I have to be able to prove a practice, policy, or procedure that a city or an entity has in place that caused or supported or facilitated that officer's or that public official's behavior. I can't do that. If I can't go and I'm getting ready to file my lawsuit, but what I do my due process, because I'm a retired federal agent. I'm in law enforcement. I'm retired law enforcement. There's my TCOL card, there's my retired law enforcement card, there's my old badge, my retired badge. It means nothing. It's just a retired badge. So I don't hate cops. I do hate bad cops. With a passion, I hate bad cops. And I represent a lot of good cops. The problem here is when I go to file a case against a law enforcement officer, I'm like, ooh, I get to sue another cop. I do my due diligence first. I file an open records request. I try to find out what information can I have. Has that officer been accused of the same thing before? Because if a police department is saying unfounded, which is what is happening in the cases that I'm filing, and then I file my civil lawsuit, and I find out that the city has actually let this guy off previously and said, oh, there was no misconduct, and yet I get my clients a nice, healthy paycheck because he is doing that. And it just so happens that my client was able to afford an attorney. This is a bad bill. It protects bad cops. I ask you to vote against it.
So you think that any individual out here in the public can just file unlimited, unsubstantiated, unfounded complaints?
No,
and that you don't believe that that's going to be used against these cops when they go to court on other cases?
Well, it sounds like the problem
that
is
attorneys will not exploit that?
Yeah, it sounds like that the problem is malicious complaining and filing of false reports. Why don't we go after the people filing false reports? That's the problem. But is that a possibility that people are going to maliciously file these complaints? Look, I know for a fact, even if it's a legitimate arrest, because I have people come to me all the time. They're like, hey, I was arrested, but they didn't read my Miranda rights, so my rights were violated. I want to sue, right? Sorry, can't do that. Your rights weren't violated. And I understand that there are a lot of people who just don't understand how police work works. And so they think their rights are being violated. They file a complaint. And guess what? That complaint's going to be unsubstantiated. Now, if it's done maliciously, I think that there are ways that both law enforcement and the legislature's already put in place about filing false official reports. You can get them for retaliation. I mean, there's all kinds of things that we can go after. But what we're doing is we're saying, you, the public, because there are some people out there that file frivolous lawsuits, you, the public, don't deserve to know that this officer's been accused of this before. And, it's not until the fourth or fifth time, or sometimes maybe just the second time, that the officer gets caught. And we need to know how many times, as attorneys and as plaintiffs, how many times did the city allow this to happen? Because am I just going to sue the officer, or am I going to sue the city who keeps condoning this behavior by finding that behavior perfectly legitimate and the officer did no wrongdoing? So that's the problem that I see from our angle. I think the best way to fix it, because I know everyone's asking, what would you do to fix this bill? Like, how could I support this bill? Very simple. Add something in there that allows for a third party, not the police department itself, not the internal affairs, nobody associated with that, some third party, whether it's a committee of citizens, that they look at the complaints. And that committee of citizens needs to include law enforcement, because they're going to have to explain law enforcement strategies and tactics and all that, because, again, let's say the complaint is he didn't read me my Miranda rights. Well, that's because he didn't interrogate you and you weren't in custody. Didn't have to. You'd have a police officer or several police officers on this committee. So I think that what needs to be fixed is, if anything, I think this bill's trash. It just needs to go away because it protects bad cops. But if you're asking me, CJ, how can we fix it? Make police complaints subject to third-party review. And I don't mean another just law enforcement agency, because they're going to protect each other. I'm talking about some kind of a committee or agency or something.
So you think other cops are just going to protect bad cops?
I see it every day. I don't think, I know.
Well, I don't think that. I think the vast majority of cops are good, and that they are like you and I. They despise bad cops. My brother's a law enforcement officer. But anybody got any other questions?
Well, just yesterday, Judge, sorry, I'm used to being in court. Mr. Chair, yesterday I had two cops come to me through a third party because they were afraid to talk to me, because they wanted to go after bad cops and what their supervisors were ordering them to do. I know there are good cops out there, and I want to protect them. What I don't want to do is protect the bad ones, and that's what this does, because it's just a blanket, it was unfounded. But how do we know this isn't a pattern or practice?
Okay. Chair recognizes Representative Hicklin.
Thank you. Mr. Grisham, so in the scenario that you presented of, going to see a history of unfounded complaints that then might together look different, why would that not be provided through discovery? Like, could you not get those records and discovery of a case?
That's a great question. And as I said at the beginning, yes, I can. But that's me as an attorney. They're having to hire me, and now they're having to pay me to draft all these documents, to get all this discovery, to go through discovery, then explain the discovery, whereas they can just pay me to do an open records request, and and do all that. Like I said I mentioned this in the Senate, that there are many departments out there, and they're usually the smaller departments, out in West and East Texas that I've dealt with, where I go to a department and I say, hey, I've got a client that said they filed a complete police report or a complaint against this officer, and it sounds like a legitimate complaint. Can I get the record of that? Oh, well, we dropped it because he retired or he resigned. And so a lot of these departments, not the big cities, because I know, I think Dallas was in here testifying in the Senate bill last month, I think it was SB 14 last month, that they have a process that it doesn't matter if the officer leaves or retires or quits or whatever, they still complete the investigation. The reality is, a lot of these smaller departments don't. When they give that officer a chance, you can leave or we're gonna investigate you. Well, guess what? Now I don't even get to see that because it just gets stopped, or in other words, unfounded. And this is reality. I'm not making this stuff up. These are the cases that I personally take where they're dropping investigations and not even going through with them because the officer would prefer, oh crap, I'm in trouble, so I'm just gonna quit. And then he moves on to the next department to become a problem. Or she, excuse me.
Thank you.
I need to show Representative Louderback present.
And that's the best sheriff in Texas right there too.
Chair recognizes Representative McLaughlin.
So first of all, I agree with you, we need to be transparent and so forth. But secondly, though, just like you said, there's bad cops out there, there's bad lawyers that use this to taint an officer that shouldn't be tainted. So they go and get a complaint that an officer has had unsubstantiated claims or they don't prove to be there, but that lawyer doesn't paint it that way. He paints this guy as a villain, and they've ruined that guy's life before he gets there. And once the genie's out of the box, there's no putting it out of the bottle. There's no putting it back in the bottle to justify this deal. We do need to be transparent, but at the same token, if we go after that person for filing that malicious or false claim, then we're here again. It comes back. It's going to be tainted that the officers are going after this individual because he stood up, and that's the problem that we have. And I saw it over and over and over since Uvalde, and in other instances there. Officers that did try to do the right thing, and there are officers that didn't. They're constantly crucified for what they did, and that's not right. I mean, these people put their lives on the line for us every day, and I'm all about transparency, and we should be. And if there's a serious incident, we need to be transparent on it. But at the same token, we have to protect these guys to some degree.
And I'm going to agree with you. I'm going to blow your mind, Representative. Most attorneys suck. I'll just say that. As an attorney. That's why I became an attorney late in life, because it's about money. It's not about justice. It's not about doing the right thing. And sometimes just because you're paid to make a cop look bad, you shouldn't be doing that. Or even just because you're paid to make a defendant look bad, you shouldn't be doing that. What I will say is, and I wish all attorneys were the way that I carry myself and why I decided to become an attorney late in life with ethics. I don't sue any cop that I haven't completely investigated, and I make sure that that guy is a bad apple and needs to be sued. But the cases that I take because no other attorney will take them. These are cases of small infractions. A guy thrown into a police car for 7 minutes for no reason, just because the cop didn't like him, right? And no attorney's gonna take that, because what's 7 minutes in a police car? Even though your rights are violated, your First Amendment and your Fourth Amendment rights are violated, they had no reason to toss you into that police car. No attorney is going to take a case where I was only stuck in a police car for 7 minutes. That's what I do. Or I can't afford to have a good attorney. That's what I do, because my job is to get rid of the bad cops, because that takes care of the good cops. When the bad ones are getting the good ones hurt. And so my job is to weed that out. But this bill makes it harder for me to weed out those bad cops because it protects them. And I'm literally on their side. I'm your best friend if you're a good cop, but I am your worst enemy if you're violating people's rights.
Chair recognizes Representative Louderback.
Hey, CJ.
Sheriff, how are you? Or Representative, which do you prefer?
They both work.
All right.
So we've known each other quite some time, have we not?
Yes, sir.
So I think what this bill is trying to do is simply extend the same protections that civil service has already, and it will actually benefit the sheriff's world immensely. And your comment about, the industry not able to police itself or not wanting to police itself is simply wrong. We simply, I have never, in many of my cohorts, we were valiantly trying to clean the industry up at all times. And It's difficult. It's a challenge. There's 2,800 agencies in this state. So it's a huge number. We're faced with systemic losses of personnel constantly. But it doesn't mean that a sheriff or police chief doesn't know exactly what's going on. And so these protections that we're asking for in this bill are simply already present in our state. Already certain numbers of law enforcement have this protection. So what we're simply saying is we want to extend it and make it consistent everywhere. Does that make sense?
It does, and I'll tell you that my opposition to this bill is hypocritical as an attorney because, for example, and I talk about this openly, I'm on probation, a probationary status. I have been since I became an attorney 3 years ago. It doesn't stop me from doing anything, and the reasoning isn't because I do something wrong in the courtroom. It's my mouth. But
I can understand that.
Yes, if someone comes in and wants to say, hey, why is CJ on probation? Guess what? Those records are protected. Now, I don't care. I'll show them to them. I'll give them everything they want to see. That's me personally because I believe in transparency. But, I'm protected by the same law that this bill, or the same sort of rules that this bill would bring in. But I would actually support a bill that reverses it for attorneys. All the bar complaints I've had, they're all unsubstantiated. I would love for everybody to see those because of how stupid and, I apologize for using that word, but, how obnoxious the complaints are. And I know law enforcement goes through the same thing. So I get it, and I do speak from a position of hypocrisy because I'm currently protected, but anybody that wants to see my disciplinary records, I'll gladly turn them over. I just want transparency on any public official, and I know I'm not a public official, but attorneys do the public's work. So, but yes, I agree with you, Sheriff. I understand this is difficult. That's why I think that instead of just defeating it, and I would hope that you could admit that there are departments out there that do protect bad cops. There are not many, but there are institutions out there, and it's really in these smaller departments where everybody's buddy-buddy with each other. And these smaller counties even. I don't even think I know of a bad sheriff's department. So the sheriffs I don't even have complaints usually against. But it's these smaller departments, and that's where I think this bill is really doing harm. And I think a separate committee or a third party that includes law enforcement on this committee, and it can even be in a majority law enforcement, that's who investigates wrongdoing, not the agency itself. I mean, if someone, really quick and I'll shut up. I had someone ask me on Twitter, I need to know who your supervisor is. So I gave him my cell phone number because I work for myself. So they called me and they said, hey, CJ's doing this, 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 and this, and this. And I said, oh, that's terrible, but do you have a problem? Let me look into it. Yeah, he's good. And I investigated myself and found that that person's complaint against me to my supervisor, who was me, was unfounded. So.
TCOPS plays a role in this too, but thank you for your testimony.
Yes, sir. Thank you.
Chair recognizes Representative DeRacio.
Appreciate you coming and testifying. And, we definitely want transparency in the process. And we definitely want justice to be done. But I'm also in favor of protecting the rights of the police officer until a thorough investigation is done.
Amen.
And then one of the things that you said in the testimony was about supervisors squelching a police officer or letting him know that, he's being investigated, and the police officer quits on his own fruition, using pressure to have him resign his position. Whenever we had a dispute on a transaction, and it was between two powerful opponents, to put something like this to a committee and the community and things of that nature, our citizenry is very astute from what I've seen, and they vote right every time. But in matters of legal, police affairs, and what some bad actor in the public is trying to do to a police officer and undermine the integrity of an individual because they're angry at him for giving him a ticket or something he justly deserved, and then to open up these records in order to accuse him, I have a hard time with that. But on some of these disputes that we have to deal with, my team would have to choose, on something like this, our team would choose a police chief or a police officer from a completely different district, and the other police officer would choose, or whoever their whoever they were, whatever department it was, they would choose another individual from a completely other district. Those two people that were chosen, they would come together and they would choose a district or a police officer to investigate. Why aren't we doing something like that here?
Well, I think we could. I will admit I'm probably a little bit cynical because of the kinds of cases that I take. But you know, the good thing is what this bill will do is make me more money, because now people will, instead of just paying me $250 to write a open records request and going over the records that way, they're going to have to hire me for a full-on case. I don't want to disparage the entire system, because as Sheriff Louderback, or Representative Louderback said, and also the chair, most police officers are good cops. But what this does is it protects that minority of bad cops that affect the most people. I mean, they're the ones that not only get their fellow cops killed, but citizens on the side of the road, or in a parking lot, but also their fellow officers, because the bad officers create resentment in the public. And that resentment translates to bad opinions towards law enforcement. Then you've automatically got that, you know, when they come together, the head beating, and then so the officer, the bad officer, will do something worse to make it worse, and then you get more resentment. You know, it's this vicious cycle. And I think the best infectant to that is just transparency. And while I would benefit from this bill passing as an attorney, because if I don't have access to those records, the only thing I can do is sue to find out if there's a case. I just don't think that's good public policy, that, well, we're going to pass this, and you know what, if you don't like it, just hire an attorney, just sue, and you'll get it in discovery. I mean, our courts are so backed up as it is. Now we've got to go through all that. I mean, it takes a lot of money and time to write a complaint and to do the investigation and get the discovery. Discovery is the worst part of any case. So that's all I'll say to that. That's all I'll say to that, I guess.
I appreciate it. Thank
Yes,
you.
sir.
All right, members, any other questions? All righty. Thank you for your testimony.
Thank you, Mr. Chair.
Chair calls Peter Hunt. Have you registered as Peter Hunt, testifying on behalf of yourself and against the bill? Is that correct?
Yes, Chair, that's correct.
All righty, please proceed.
Thank you. My name is Peter Hunt. I'm testifying against the bill, representing myself, and I wanted to bring up some concerns related to some unintended consequences with the text of the bill as it stands. Now, on the Senate floor last week, there was some conflicting conversation about what exactly would be covered and what could be overruled here, and so I wanted to address that. I'll do what I can to cover it in the time available, and I'm happy to take any questions. The first part I wanted to talk about was this issue of body-worn camera footage. Now, the text of the bill as it stands looks like it would prevent the authorized disclosure of body-worn camera footage. This is because the bill itself says that a department file maintained under this section is subject to disclosure only as required by law, and then lists a couple other laws that have to do with body-worn camera footage. And though that language of referencing these other sections of the Texas Code was put in by the Senate to try to address this issue. Now, body-worn camera footage is often proactively disclosed by chiefs of police in response to these complaints, and this gets precisely to the testimony that was just given, that if there's a complaint brought against an officer and the department wants to address that and say, no, that complaint was illegitimate, let's clarify why, in a way that establishes transparency, builds trust, and actually helps resolve this issue of unfounded complaints being used against officers, that would be prohibited by the bill text as it stands, just on paper, whether or not that's the intent. And this is because the section of the language that refers to the disclosure of body-worn camera footage only authorizes disclosures. It does not require them. And as I said, the law says disclosure only as required by law, which means that optional proactive disclosure by a department would still be prohibited, even if the intent is to do otherwise, is to allow those disclosures. So the bill, I believe, should be amended, at the very least, if this is going to be an issue, to respond to that by allowing not only required by law disclosures, but any authorized by law. So that's, I think, the first unintended consequence of the text as it stands, just going back to what's on the page to bring up. The second has King said that his intention in response to some questions on the Senate floor was that meet and confer agreements as they currently stand should be able to supersede parts of this law, so that those agreements that have already been put in place can continue forward on the terms that were mutually agreeable at the time. Unfortunately, it does not seem that this is clear. I've elaborated on this with various members of y'all's staff earlier this week, but it's not clear that meet and confer agreements actually can supersede state law, especially parts of the operations code where this would be located. And there are good reasons for that, and it seems like the only way to resolve that, if this bill is passed out with its current text, would basically be through a lot of case-by-case litigation. My time is up, but I'm happy to take any further questions.
Members, any questions for this witness? Okay, we thank you. Thank you for your testimony. Chair calls Mary Elizabeth. I show you registered as Mary M. Elizabeth, testifying on behalf of yourself and the Austin Justice Coalition and against the bill. Is that correct?
That's correct.
All righty, please proceed.
I'm speaking about serious emotional trauma resulting from police shootings and the need for families to have access to all law enforcement records of the incident. Although the Uvalde shooting on May 22, 2022 was not a police shooting, the lack of law enforcement action that day was just as devastating to the families and children of Robb Elementary School. The extreme level of trauma they experienced is diagnosed as post-traumatic stress disorder, or PTSD. The law enforcement officers who were present then undoubtedly are affected by this as well. PTSD disrupts lives and shatters families. It manifests in a myriad of disabling emotional and behavioral problems ranging from panic attacks to suicide. The children at Robb in 2022 are growing up. Their normal developmental progress toward adulthood is significantly challenged and might be delayed. It will affect how they parent their own children and will limit their life prospects. As one Uvalde father verbalized his own trauma, it's just really hard because I know how my children were before the shooting. The families need to know in order to process all of what happened and not be left with unanswered questions that intrude in their lives every single day. The records provide vital information that they can't get anywhere else. Without knowing the reality of what happened, instead of healing, they will be left with a disturbing emotional weight they will carry for the rest of their lives. Additionally, these families and the entire community can no longer depend on their law enforcement agencies and state government to protect them. These agencies will only regain respect when they are accountable and transparent about these murders. Thank you.
Thank you, members. Any questions for this witness? All righty, thank you for being here. We appreciate your testimony. Chair calls James Songer. I show you registered as James Songer, testifying on behalf of Dallas Police Department.
Yes, sir.
And yourself, and for the bill?
Yes, sir.
All righty, please proceed.
Yes, sir. Good morning, Chair and committee members. My name is Lieutenant James Songer, and I represent the Dallas Police Department. The Dallas Police Department is in support of Senate Bill 15 as an opportunity to make some specific reports confidential. Automatically generated reports related to officer performance and its attendance provide a good starting point when addressing an officer's productivity. We would like to utilize these reports as part of an early warning system, but we are not a Chapter 143 civil service agency. We're a municipal civil service agency. As a result, reports related to an early warning system, including performance improvement plans, will be subject to release even before their accuracy is verified. Additionally, reports related to an officer's use of sick leave, vacation leave, and when they choose to take their holiday are subject to release and are not currently confidential. and an officer's performance or attendance rises to a level of misconduct through violations of policy or law, then it becomes a matter of public concern, and our department has no issue with releasing that information. Until such scenario, we would like to keep attendance and performance-related reports confidential. Thank you for the opportunity to speak in support of this bill and on behalf of the Dallas Police Department, as this bill provides us with an avenue to be a responsible employer by developing our staff and implementing a robust early warning system.
So when you're talking about the attendance record of someone being put in their file and being subject to public before you can even
Yes, sir,
verify
correct.
if it's
And,
accurate,
a
that
real
could be,
example-
that is
oh,
something
sorry.
that could be irrelevant to a case being brought that a lawyer could use to, he could exploit that to discredit an officer.
Correct, yes, sir. And another good example that we did have happen was we had an estranged husband, ex-husband, do an open records request on his wife, and there were some family violence issues going in there to figure out when she was taken off and making sure he was around while she was off. So we believe that would protect the officer in their personal life also, making that confidential.
Okay, so some of these records can be used against these officers in their private lives even?
Yes, sir.
Okay.
Correct.
Chair recognizes Representative McLaughlin.
So the question that I have is going to go back to a mass casualty incident like the Robb School shooting or so forth. Do you support, or would this bill, in your opinion, shield those officers from review of their conduct on that day and releasing the information of that day?
Not at all, sir. I don't believe this bill would affect that at all. I mean, the amendment that was added in the Senate says, as required by law, that requirement would already, I mean, we already know that's going to be by law anyways. And as far as a body-worn camera, that's a complete own statute. So also, those videos would be governed underneath a different statute than what this bill would do. So yes, sir, I believe those would be subject, not maybe to open records, but definitely to the legality part of it. It would be presented in public.
Okay, well, I mean, legality, that's the problem we have, I think, in some of these instances that we have now. And I'm going to harp on Rob, and I hate to use that
Sure.
as a deal, but we're 3.5 years there, and we still have videos that aren't released. We still have departments that haven't released reports. And for me, if this bill is going to codify that, where you can do that, then I would be a no on it.
This bill does not even, because you're talking about video specifically, this bill does not touch on videos. This bill is departmental documents that we're utilizing. That body-worn camera and the dash cam videos, that's all underneath a separate statute. So no, this bill would not affect that.
Okay, well, I mean, some of it's not just the video, there's even code of conduct that's
Right.
not being released at this time, which to me, from that day, we're all big boys, we made mistakes, whatever, we need to lay our cards on the table and deal
Completely
with it.
agree with you, sir. That was a horrible incident. I completely agree that I do not believe this bill would affect making those records public.
Okay, thank you.
That's what I believe.
Chair recognizes Representative Holt.
Thank you for being here today. I just want to clarify, so about the body camera, the footage and all of that. So that footage does not follow a particular officer? Is that what you're saying? It's in a different setup? Explain that for me.
There's state law already regarding body-worn camera. There's a separate body-worn camera statute and code of criminal procedure that the police departments have to follow. And the only person that's really authorized, unless it's legal, is always handed over to attorneys and stuff. But the chief of police has to authorize the release of those already. That's nothing to do with this bill.
Okay.
So there's a statute that governs body-worn camera and dash cam also.
Okay,
So
so-
that's not really related to this bill.
So body cam footage could not be buried in a file somewhere and protected that way?
No,
with
no,
this
ma'am,
bill?
I do not believe it would.
Okay.
It could be or would be. I mean, our body-worn camera is loaded to a cloud, evidence.com. Now, we do make copies of that, but it's just a copy of what the actual video is.
Okay.
So no, ma'am, I do not believe this bill would affect that at all.
Okay, thank you.
Chair recognizes Representative Louderback.
Thanks for your service, Lieutenant. Let's be real clear here, just so the committee knows. Any investigation that a law enforcement officer has, if he resigns from that agency, doesn't that follow him?
Yes, sir. So not only that, but because of the sunset bill, they put in place last session, any pending investigation, even if officer quits, the department is required by TCO to complete that investigation.
Thank you.
And that will stay in their file that is subject to any other police department that's going to be hiring that officer. They can get that file and review that also.
Appreciate
Even the unsustained complaints would be reviewable by that hiring agency.
Thank you.
Chair recognizes Vice Chair Lopez.
Thank you, Chairman. Yeah, thanks for being here to testify. There was an issue that was raised that certainly, resonates with me, and I would love to get your opinion on it, that this applies to all departments across the state, regardless of size. And it's really difficult sometimes to craft something that is one size fits all. What are your thoughts about that? I mean, obviously, Dallas, San Antonio, Houston, Austin, all those are large departments. How about the small ones, which there's a large amount of? How would you square that with the small ones?
I'm really only supposed to give testimony on what my department does.
Sure.
But I would say that in that scenario that CJ was bringing up, in all honesty, if a citizen calls a small department to complain on them, there may not be paperwork to begin with anyways, because if they're going to cover up for their officers, they're just going to tell the citizen, oh, we'll take care of it and hang up the phone. So that's already going to be an issue without this bill. They're just going to not take the complaint. And I imagine some small departments probably, hey, we'll talk to that officer, we'll take care of it, and we'll investigate it, but maybe just word of mouth, hey, don't do that again. That's not really something that's going to follow them, right? So I would imagine that if that's happening at a small police department, it's going to continue to happen if this bill is passed or not.
And we may have some witnesses later that cover some small agencies that can get down to that in a granular.
Okay, great, I appreciate it. Thank
But
you.
like the one-man police departments, I mean, the mayor would be, from my experience, the mayor would probably be responsible for investigating that small of a police department in a citizen complaint.
Thank you.
Members, any other questions? All righty. Thank you for being here.
Thank you.
Appreciate you.
Appreciate it.
Chair calls Robin Kirschenbaum. Did I pronounce that correctly? Yes, you did. Awesome, okay. I show you registered as Robin Kirschenbaum, testifying on behalf of yourself and against the bill. Is that correct?
Yes.
All righty,
thank you.
proceed.
Chairman and committee members, thank you for hearing my testimony. I feel that jails require a separate analysis of the documents that will be closed. Bexar County Jail has just returned to supervision after a scandal involving guards who let gang members into cells to beat them over failure to repay small loans. These beatings had been going on for at least a few months. No jailers had been disciplined. Had someone not died during an independent Sandra Bland investigation, those beatings would still be going on probably. Harris County Jail has been subject to many inmate complaints about being punched in the head unreasonably by guards. None has resulted in discipline, and it was not clear the complaints were being investigated. Eventually, a news organization asked for video, got that video of hundreds of incidents, and published its findings in December of last year. Then, the sheriff announced that some of the beatings were against policy and began to issue discipline and consider policy changes. Tarrant County Jail, after the death of a local gun rights activist, Mason Yancey, is still under fire for its substantially higher than average rates of deaths in custody and the death of a baby who was not counted as a person. The sheriff has been failing to bring in outside investigators and instead conducting internal investigations, getting the Fort Worth PD to rubber stamp them and sending them to those files to the Commission on Jail Standards. During this past regular session, the commission announced that the practices were non-compliant and has clarified what a Sandra Bland investigation requires. Representatives from the Texas Jail Project in Houston came to this building during the regular session to give you a better picture of the extent to which inmate complaints are not investigated. Misconduct is allowed to fester in a culture of impunity, and the extent of the work that will be needed to improve oversight and accountability. This bill will do the opposite of that. There has not been due consideration to the special duties to the voters and the public when it comes to the conditions of pretrial incarcerations, which is what the vast majority of inmates are serving. If you continue down this path, I ask that you exclude jails and jailers from the scope of the bill and make sure a full public vetting occurs before documents, now public, documents that have revealed both problems and have launched jails on a path to better conditions becomes confidential by law. Thank you.
Members, any questions? All righty, thank you for your testimony.
Thank you.
Chair calls Kathy Mitchell. I show you registered as Kathy Mitchell, testifying on behalf of Equity Action and yourself and against the
sir.
bill. Is that correct?
Yes, sir.
All right,
Thank you.
proceed with your testimony.
Thank you all. I think that a sign that this is not ready for prime time is the degree to which we are all coming up here to try and figure out what it means. Court's job is to harmonize competing laws. This bill very clearly says that any document relating to a license holder becomes confidential. We've had a number of people explain that that is personnel documents or that is documents related to algorithms that are going to go into a red flag system. To be honest, every time I hear testimony, I understand better what documents proponents actually want to make confidential, and that is incredibly useful. I think that there is a path to an agreed bill here, a largely agreed bill. But this bill is not it. Because right now, and I want to lean in a little bit to the debate, let's call it, over body camera footage. The body camera footage law is a standalone law that authorizes, it does not require release. That release is very useful to police departments for building trust between police and communities. And sometimes it just rips the Band-Aid off things that need to be released. That law has two sections. The first authorizes release in the event that a chief determines it's in the interest of law enforcement, and that's that flexibility piece. And the other authorizes release unless there is authorizes release, but allows agencies to use all the exceptions to disclosure that are in the Public Information Act. One of those exceptions to disclosure, of course, is the 101 exception, things made confidential by law. This bill creates a confidential by law law. I will guarantee you that this law will send all of the discussion about Uvalde and other cases back to square one legally, because a judge is going to have to harmonize the intent of this law with the intent of the law that says everything is, you can release it unless it's confidential under one of the exceptions to Public Information Act, and the first exception is 552.101. Now that is just a narrow analysis of one law and one situation. When you say you are making any document confidential if it relates to a license holder, you are going to throw into disarray many laws that have been working more or less just fine up until now. I think that the back and forth that we've seen over this bill, over the application of Michael Morton, and the need to have some kind of clear pipeline that addresses the Michael Morton Act and the possibility that defendants are not getting the information they're constitutionally required to get in criminal cases, is an example of how hard it is to do this when you start with the framework that everything is secret unless, and then here are the exceptions that apply. So I just want to say, I think this bill still needs work, and I think an interim study where we actually lay out the documents that have been of concern, the abuses that we're seeing in the real world, and try and build a system that addresses the abuses. To your point, sir, a system where there's any kind of external review would be an improvement in many of those smaller jurisdictions than what we have now.
Members, any questions? All right, Ms. Mitchell, thank you for your testimony. Chair calls Paige Williams. I show you registered as Paige Williams, testifying on behalf of the Dallas County District Attorney's Office.
Yes.
Is that correct? And you're neutral on the bill?
Yes.
Okay. Go ahead.
Again, my name is Paige Williams. I'm here representing Dallas County Criminal District Attorney John Crusoe, and we are neutral on the bill, primarily because we support the policy behind this. And I want to make sure that everybody understands what we're trying to do here, is we're trying to thread that needle where police officers and subsequently our criminal cases are not being tried in the court of public opinion before we can actually take care of them. And part of doing that, the way that this is crafted, is that we are moving to letting all law enforcement agencies have a department file and a personnel file. And to be clear, the things that will go into the departmental file are unsubstantiated claims. The reason that we are neutral on the bill is because we do believe that there should be a carve-out for district attorneys' offices, specifically for criminal cases, across the board, because there is another policy issue at play that hasn't been discussed, and that is going to be balancing the labor rights of a police officer with the constitutional rights of a defendant. That is something that I definitely want y'all to think about. But again, we are neutral on the bill, and we discussed this with Senator King, and that is why he made the change to unless otherwise provided by law in his bill. So we definitely believe that we are moving in the right direction, and we can live with the language that is there. And I'm happy to answer any questions, but to answer some of the questions that have already been asked, in regards to small law enforcement agencies, I was a former rural elected DA, and I can tell you in a small agency, if anything happened, the whole community knew about it. It was already public. Officer transfers and whether or not their personnel information transfers, y'all covered that in the 88th. Gypsy Cop Bill was done in the 87th. So those protections for misconduct officers have already been put in place in law. And again, the change that Senator King made encompasses all of that. So with that.
Members, any questions? Representative Pearson.
Thank you, Chairman. Thank you for being here. Could you just go a little bit further with what you were speaking about for DAs specifically? What exact language are you thinking we might need here?
So currently in the bill, and I believe y'all did this, it was the 87th that did this, there's a carve out for other law enforcement agencies that they can have access to everything when an officer transfers. And under the new model policies under TCOL that y'all did under the sunset last session, if they can't leave an agency under, dubious circumstances, because that investigation will have to finish and go with them if they try to change law enforcement agencies. And so as far as DAs go, we would like to also just be included in that carve out, because at the end of the day, every county does it differently. Like Harris County, we know, does protective orders for the department file. Austin, I believe, I just learned, also does protective orders for the department file. We don't in Dallas. And ultimately, when those are negotiated, they're negotiated pre-trial. And it's our position in Dallas is that pre-trial, a judge, one, a defense attorney is not required to tell you why that information is relevant because they don't have to tell you their case. And two, we might not know as prosecutors if that department file is relevant to anything in the case. So if you just open it up so that we can see all of it, then you have a criminal attorney as opposed to a civil attorney who is usually arguing these labor issues. You'll have a criminal attorney looking at it and saying, hey, this does fall under Michael Morton. This does fall under Brady. This does, and we'll have to turn it over. Because from a criminal standpoint, unlike the bad officer case, what we have is we have defendants who have, like one officer could handle thousands of cases in their career. So one bad act or one unsubstantiated act that might be relevant to a defendant might be relevant to thousands of defendants. And what we don't want is the Michael Morton case 25 years later, where a police officer found something that wasn't relevant, turned out that it was the linchpin to the case. So that's why we would still advocate for a carve-out. I understand that, that's a bigger discussion, which is why we are on the bill, because we understand right now the court of public opinion versus the sanctity of our cases is at risk here. So,
Okay, thank you very much.
you're welcome.
All right, members, any other questions? All righty, thank you for your testimony.
Thank you.
Chair calls Justin West. Have you registered as Justin West, testifying on behalf of Galveston County Precinct 4 and yourself, and for the bill, is that correct?
Yes, that's correct.
All righty, proceed with your testimony.
Thank you, Mr. Chairman, Vice Chair, members of the committee. I'm Constable Justin West from Galveston County. I have an agency of between 9 and 12, depending on how many reserves I have at the point in time. One thing I want to address, and I'm going to reiterate what she said and a couple others, is TCOL, after sunset, has put together policies. There's already been a addressing for the wandering officer. The investigations that have to be completed regardless of employment status, the removal of the F5 classifications. So a lot of times in the past, agencies say, well, if you'll just resign, we'll give you a good F5. Now that's gone. We have to complete investigations. And within 90 days, those have to be uploaded to TCOL. So it doesn't matter if they left or not, they're still going to be investigated. That is required. So if an agency isn't doing that, so the one-man agencies still have to be investigated. And the idea of investigating yourself is not proper law enforcement. So to believe that investigating yourself is going to happen, it shouldn't. If it does, that needs to be addressed some other way. So the saying goes, where there's smoke, there's fire, right? So when you have an officer who deals with the same violators regularly and the violators just get tired of being dealt with, they start filing complaints. Something even more simple than that is a traffic stop where someone didn't want to get a ticket. Well, now you're going to get a complaint because, oh, that officer was mean to me or didn't take into account that I was sick or whatever the case might be. We still have to investigate those because they're sworn complaints. So if we're going to have all that out there, now it's going to become this large movement of the social media and I heard the Court of Criminal or the Court of Social Justice and online opinion and all those things. That's going to become the way people are going to move. They're going to start going out and making these complaints because they know they can affect the officer's career, maybe their family life, maybe they're staying in the community. So we need to protect our officers in that regard. The point of what our attorney said earlier is he wants to be able to see everything because it becomes a subpoena instead of a public information request. Well, if we go down the road of just releasing everything, there's already officers protected by this, so now we're not being fair. The committee that built this policy that this legislation is based on was civilians, it was law enforcement officers, it was statewide, it was people from rural environments, it was people from the urban environments. They met for 6 solid months everywhere in the regions in the state. So everyone had an opportunity to give opinion on this when it was being drafted, and that's why it came out the way it did. Labor groups were involved, again, law enforcement, defense attorneys, prosecutors, everybody was at the table for this. So The legislation is simply codifying what was put into that policy. And what we are actually operating under that policy right now. We're just asking for you to report favorably to the floor and for it to finally pass and codify that language for us. And I'm available for questions if you have any.
Members, any questions? All right, Constable, thank you for your
Thank you so
testimony.
much.
We appreciate you being here. Chair calls Jim Crosby. I have you registered as Jim Crosby, testifying on behalf of yourself and against the bill. Is that correct?
That's correct,
All
thanks.
right, proceed with your testimony.
I want to address briefly 3 issues raised by the bill: use of force reports, complaints filed, and separation reports and separation data. But because I tend to go long, I want to start with my conclusions, if you'll bear with me. The list of documents goes well beyond those 3 issues, and reports of public interest with respect to a police agency or jail, much longer. And yes, they are in many different files. I would ask that you consider conducting an interim study that actually examines the information now subject to Public Information Act requests and sometimes actually given to reporters and the public, whether the release of such documents is in the public interest and whether the interest of the officer can be addressed in some less harmful way than sealing the records altogether. I would also ask that you look at the various exceptions that already apply and whether they already address any concerns officers may have. So first, use of force reports. The most important case that currently defines what is and is not secret in Chapter 143 cities is San Antonio versus San Antonio Express News, in which courts determined that when an officer fills out a use of force report after using force, that report is not personnel information. Courts have said this is not personnel data. That analysis would be superseded by this new analysis. Does it relate to the officer, and is it one of the listed, quote, public documents? The answers are clearly yes and no, so it would be sealed. The downside is a significant loss of public transparency and confidence around one of the most often raised issues with policing. In most cases, the data and the reports are used to evaluate the conduct of entire units and the larger force, or conduct by sector. This can be done without the name of the individual officers. The reporting almost universally shows that force incidents involving injury are rare, but sometimes it also points to certain units that need retraining or may need some staff to be rotated out. And taken together with the next item, complaints, it can help community groups have better and more informed conversations with department leadership. So cutting to the chase now, complaints filed. A complaint filed against an officer is, quote, personnel information and could still be protected by this bill under language that narrows the confidentiality to personnel information. A complaint filed with an agency in which the name of the officer and any identifying information has been redacted is not personnel information. Under a narrower version of the bill limited to personnel information, complaints could be made available in a redacted form. And I'll go ahead in my last few seconds to deal briefly with separation reports and separation data. Similar to complaints, separation reports and the exit information reported by separating officers are personnel information and are also important for public accountability when agencies are struggling with retention. Separation reports are personnel information and could be made confidential in a narrower personnel file system. Thank you.
Members, any questions for this witness? All right, and Mr. Crosby, thank you for being here.
Thank you.
Chair calls Robin Foster. I have you registered as Robin Foster, testifying on behalf of the Harris County Deputies Organization and neutral on the bill. Is that correct?
That is correct. I
right.
also have handouts, but without the clerk.
We can do it.
Thank you.
All righty, go ahead and proceed with your testimony.
Good morning, Chairman Hefner and members. Thank you for the opportunity to speak with you. My name is Robin Foster, and I represent Harris County Deputies Organization Fraternal Order Police Lodge 39. I am also joined in these comments by the Texas Municipal Police Association, the Houston Police Officers Union, and the Austin Police Association, and the Dallas Police Association. I am providing a handout to the members today that outline the legal aspects of our position, and I can answer any questions regarding that.
In simple terms, we would like to make the committee aware of what we see as lack of protections for confidential and sensitive information that is going to be mandated held indefinitely in these department files. This includes personal medical information of the officer, leave information, and unsubstantiated complaints. What I mean by complaints against the officer, that is after an investigation has occurred and no policy violation was determined, those are unsubstantiated complaints, meaning the officer has been found innocent of the allegations. This proposed language does not seek to curb Michael Morton Act or Sandra Bland Act. We fully support those requirements. What we are asking is that a judge make a determination in camera what shall be disclosed and an automatic protective order be put on those documents. The process outlined here is similar to that given to officers in agencies with specific meet and confer agreements under 143, such as the Houston Police Department. 143 allows for contracts to protect safeguards of employees. We are asking is that these same safeguards be given to all officers and jailers in order to protect their personal information, as well as the information this bill makes confidential. So the purpose of this bill is to keep things confidential. We're just asking for a protective order on these things when they get disclosed through the Michael Morton Act, in order to keep it within the case at hand and not become a media circus. Thank you for your time and consideration in this matter.
Thank you for your testimony. Members, any questions for this witness? All righty. Thank you for being here.
Thank you so much.
Chair calls Elizabeth Miller. I show you registered as Elizabeth Miller, testifying on behalf of yourself and against the bill. Is that correct?
That's correct, and
All
I
right.
have some
Proceed with your
sheets for
testimony.
y'all.
Yeah.
If I may. Thank you, and good morning. My name is Elizabeth Miller. I'm here testifying on my own behalf. I am also a policy director for Republican Liberty Caucus, and I have a lot of concerns about this bill, too many to get into here, but I wanted to let everybody know that I suspect many of them are similar to the ones that Senator Hall has. He's opposed to this bill. Campaign for Liberty is also opposed to this bill. I don't have enough for the whole class, I apologize, but I do have here a couple of copies of a bill analysis from Texas Policy Research, and their job is to, they look to defend, all of these organizations look to defend individual rights and limit government, and are concerned about the incentives that we're building in here that could increase corruption, the risk of corruption, the risk to transparency. But you've heard about some of those today, and again, we don't have time, so I want to incorporate some of those concerns. I must say, though, I'm an old civil trial lawyer. I've been plaintiff in defense. I represented the nation's largest retailer for a number of years in what was probably thousands of cases. And I respectfully disagree with some of the representations about how a court will interpret some of this. Shall means shall. Confidential means confidential. Documents in civil litigation means everything, real or digital, that contains information. Now, then we debate about relevance and things like that, but documents is almost everything in the law. So I respectfully disagree to some of the representations about how this will be interpreted by a court. This is aggravated by the fact that this is a new law since those other laws. Just because you say, except provided by law, doesn't mean that the other law trumps. It just means it's there. This one says confidential and all persons. That's very broad. And I think you've heard enough concerns here today that it's safe to say this is just not fully baked. I understand the concerns. I want to go after them. But some of the reasons that you will find in the piece from Texas Policy Research about their concerns have to do with some of what you've heard, and that is defending the actions of a good cop and good policing. My brain goes there because, again, I represented the nation's largest retailer. So in incidents that happen in the store, so I'm sort of defending the associates, so the analogy, that's where I go. How am I going to show that a good cop or a good associate or a good manager did the right thing if I don't have the documents? I need the reports. If they say, oh, that associate walked by that spill a dozen times, I need what the law considers documents, essentially everything, to show that they did the right thing. So I have a lot of concerns. I urge you to please wait. Republican Liberty Caucus urges you to take the interim to really think this through a little better, and I welcome questions. Thank you.
Members, any questions? All righty. Thank you for being here. Thank you
Thank
for your
you.
testimony. Chair calls Wendy Tippett. I show you registered as Wendy Tippett, testifying on behalf of yourself and against the bill. Is that correct?
Yes, sir.
All righty, proceed with your testimony.
Good morning. My name is Wendy Tippett, and I stand before you today not just as a citizen, but as a mother whose life was forever changed. On September 14th, 2022, my son, Timothy Michael Randall, was killed by Rusk County Sheriff's deputy during what should have been a routine traffic stop. In less than 2 minutes from being pulled over, my son's life was taken. He was 29 years old, unarmed, and less than an eighth of a mile from his home. As devastating as that was, what followed was another kind of cruelty. It took me 2.5 years, over 900 days, in a federal lawsuit just to gain access to the dash cam footage of the incident. 2.5 years of silence, 2.5 years of stonewalling, 2.5 years of torturing myself with every possible scenario I could think of that would make it make sense to me because my son was a kind and respectful young man. 2.5 years of not knowing the truth about what happened to my own child. I'm here today because no family should ever have to fight this hard just to know the truth. Just to know the truth. Transparency is not optional. It is the very foundation of trust between law enforcement and the communities they serve. When evidence is withheld, trust in law enforcement and government collapses. When families are silenced, when the public is kept in the dark, the damage extends far beyond one case. It erodes faith in every officer, every department, and in the justice system itself. Justice cannot survive in secrecy. I stand before you today to say that we can and we must do better. True justice cannot exist without truth, and truth cannot exist without transparency. I'm asking you as lawmakers to take action. Mandatory required release of body and dash cam footage in cases involving serious injury or death within a reasonable time frame. Timely access for families, and ensure families have timely access to reports, evidence, and belongings of their loved ones. Independent investigation. All misconduct cases must be investigated and tried by an outside independent agency, not by the same agency for department involved. These steps are not anti-police, they're not pro-accountability, they are pro-accountability, pro-community, and pro-justice. Good officers deserve to work in the system that is trusted, and families deserve honesty. And every life deserves dignity, even in death. My son deserved better, the people of this state deserve better, and you as lawmakers have the power to ensure that no mother has to stand before you begging for the truth. Michael's life mattered, his story matters, and what happened to him must mean something. Let his memory be a reason why we commit right here and now to transparency, accountability, and change. Thank you.
Members, any questions for this witness? All righty, Ms. Tippett, thank you for your testimony. Chair calls Alicia Castillo. Show you registered as Alicia Castillo, testifying on behalf of the Texas Civil Rights Project and against the bill. Is that correct? All righty. Proceed with your testimony.
That's correct. Alicia Castillo, representing the Texas Civil Rights Project. And the first thing I want to mention is that there was a lot of talk about misconduct during this hearing, and I wish that this was really a legitimate conversation about just misconduct, but it's so much more than that because the language of the bill before you says that what will be concealed going forward if this bill passes is all letter, memoranda, or documents related to a license holder, including records of unsubstantiated misconduct, not limited to, including all records related, all documents. And so what I've handed out before you today is a legal memo from our legal team at Texas Civil Rights Project that does interpret, as many folks here today have interpreted documents and related to mean everything. That interpretation is actually shared by Senator King, who said on the floor during the floor debate that all documents means everything. So that was Senator King's read of the bill. Perhaps there's a disagreement from this chamber, but we have concerns with including every document related to a license holder in a confidential file. Another thing that I'll mention, I know this has been talked about before, we discussed the tragedy in Uvalde that families are still dealing with to this day. The section of the Code of Criminal Procedure that talks about body-worn camera footage is Article 2B.0112. That is where the code talks about exempting release on discretion of the agency. So despite the noble effort of amendments from members on the other chamber to protect some of these things, it doesn't actually do that because, again, the code that it references in this bill goes back and says that the release of that footage is discretionary according to the agency. But also in this bill, it wouldn't exclude documents like 911 call logs and audio. It wouldn't include security camera footage. In fact, today, families in Uvalde are still battling in the courts over gathering security camera footage from what happened that day because DPS is currently in custody of that, and DPS is fighting the release of that footage. Another thing I'll mention is that this independent investigations thing, I understand that some members of this committee might feel that officers are infallible and wouldn't cover for one another. But unfortunately, the TCOL model policy rule, that's 2.1 under the misconduct policy, this is mirrored in the occupations code under 1701.001 that misconduct is that which may result in a suspension, demotion, or termination. That's misconduct. And additionally, what TCOL says must be done to initiate an investigation, it just says an appropriate investigation must be done to substantiate or unsubstantiate misconduct. That is not a high enough standard for us to feel like unsubstantiated claims are false complaints. So I can share, I have more points if there are any questions, but respectfully, thank you for your time.
All righty, members, any questions for this witness? Representative Pearson.
Thank you. Thank you for being here and testifying. You said that an appropriate is not really valid because there's no definition. What would you define as an appropriate investigation?
Well, I would recommend, I mean, you've heard a lot of conflicting testimony today, that this be a broader discussion. And then I would mirror the request of some other witnesses that this be an interim study, because appropriate to one person might mean something and might mean something else to another person. But at the bare minimum, a uniform standard for independent investigations is really important. And I think many people have said that today, independent. I heard one deputy say that, well, in smaller agencies, the mayor will do it. Okay, if that's true, then maybe we should put that in TCOL model policy, that some independent body will do that investigation.
So is your concern with that piece of it just that it's just too vague?
That's part of my concern. Appropriate administrative or criminal investigation is ultimately going to be determined by the law enforcement agency. So in this case of small departments, or perhaps a sheriff in a jail, if it's a very small agency, appropriate. If there is no requirement for them to contract with some outside agency or body, appropriate might just mean that I've looked into myself and found complaints to be unsubstantiated.
Okay, thank you.
Thank you.
All right, Representative McLaughlin.
So my understanding of the intent of this bill is to seal unsubstantiated claims to be used against an officer as I said earlier with the attorney earlier, is just like he alludes to bad cops, you allude to bad attorneys that use unsubstantiated claims to paint a picture of a villain. That's usually not the case. But you're saying this goes beyond that and seals everything, not just the substantiated claims?
Yes, sir. That's exactly my read because it says all letter, memoranda, documents related to a license holder, including those related to unsubstantiated complaints, not limited to.
Isn't there already law enforcement agencies out there today that are already using this and protected by this today, a good portion?
Well, there is the G file, right? We have about 70 cities who are civil service cities, and they get the G file, this secret file held by the department that contains records like these. The G file has a lot more listed about what goes into the G file than this bill does. There is no list, to my knowledge, and it could have changed before.
Well, you keep saying that it says all documents, but this says.
I'm sorry.
Well, it doesn't say that either. It says any letter, memorandum, or document relating to the license holder not included in a personnel file. So there
Right.
are other files and other things that are disclosed to the public that are stored in the personnel file.
And the personnel
So
file.
not everything goes in the department file. So that's a misrepresentation of what this bill is talking about. There are things that are disclosed to the public that go into the personnel file. And then there are things that are not disclosed to the public that go into the department file. And those things are letters, memorandums, unsubstantiated claims, and the things that we've talked about all day. So
Yes,
just make
sir.
sure we
And
keep
in the
that clear.
Occupations Code, Chapter 1701, we get a list of what's in the personnel file. And that includes commendations of the officer, that includes some supervisory notes and other things related to misconduct.
Yeah.
And that's it,
No,
that's in
not
the personal.
coaching and
coaching,
maybe
yes.
correcting the officer.
Supervisory notes, yes, sir.
I wouldn't say that's related to misconduct.
Sure,
That
okay.
If it
Well,
rises to misconduct, I think it's going to go into a different file, would be my understanding, so.
And I would understand it that way too if the bill was limited to misconduct and it didn't say including unsubstantiated misconduct, but was more specific about those types of documents. And while we would still not be in favor of that, because again, unsubstantiated does not mean false, that would really clarify, I think, for a lot of the people that have some confusion about this bill. While again, the stated intent being to protect officers from unsubstantiated complaints being made public, it's not my read of it. And the personnel file is incredibly limited. So I could, I think you probably have that code near you, Occupations Code 1701, that outlines what that list is. But what is public in the personnel file is not going to include all of these other things that I've mentioned: 911 call logs, audio, security camera footage, body-worn camera footage, and critical incidents.
Their
The
health
list could go
history,
on.
their days off and things so that people can't nitpick their personal lives also.
Yes, sir. And that's why SB 1569 from this regular session was so important, because Senator King acknowledged that releasing sensitive personnel information is not appropriate. So that bill allows a redaction of personally identifiable information. But that bill goes into effect in about 2 weeks here. And so one other recommendation would be allowing us to implement that bill, redact personally identifiable information from our public servants, and then take a look and see if we still have this problem that officers are concerned with about their information being released, because I believe Senator King's bill, SB 1569, should protect for cases like that once implemented.
Okay. Any other questions, members? All righty. Thank you for your testimony.
Thank you.
Chair calls Chris Harris. Show you registered as Chris Harris, testifying on behalf of the Texas Civil Rights Project against the bill. Is that right?
Yes, that's correct. And
Proceed.
Thank you so much for the time. And I'll just follow up on my colleague's testimony here. The point about the personnel file is well taken. There are three main things in the personnel file that would be excluded from this department file, which would be largely confidential in perpetuity. As was mentioned, those include honors, commendations of the officer, sustained misconduct, information from the agency about sustained misconduct would be in the personnel file, and that could be released. And then you have the regular, review of the officer, a note about their regular review. So those three things. It was also mentioned in previous testimony, court cases that have found that things like use of force reports would not go into personnel files. So what that leaves in the department file is everything else. So everything that's not a commendation, the sort of regular review of the officer, and the sustained complaints leading to that the suspension, termination, firing. Those are the things are going to be put into this, under the current language of the bill, into this department file, and ultimately be confidential in perpetuity from almost everybody. And again, to the point, this is not just unsubstantiated complaints. And again, we also have an issue with what that means, because again, it doesn't mean false, because we don't always have an investigation that actually occurs with related to those. And again, especially if the issue is not something that under TCO could rise to the level of necessitating a suspension or a termination if found to be substantiated. So we have an entire world of things that may not result in an investigation, may not ever be subject to disclosure, that would get thrown into this pot under the notion that these are false complaints that would be harmful to an officer. But in actuality, could include things like use of force reports, could include things like incident reports, could include things potentially like body cams, based on some of the interpretation that you've heard here today, despite the recent amendment to the bill. Could include, obviously, and then the issue at hand, which is the actual complaints that could or could not be valid, but for whatever reason, maybe because of the size of the agency, their ability to undertake an investigation, the lack of ability to find a third party to conduct an investigation, or a simple unwillingness on the part of the agency leadership because the incident was embarrassing to them personally, and they don't want to substantiate it and make it part of the personnel file that then could become public. These are all issues where this bill is potentially creating a very wide net of secrecy that would include the things like the Uvalde case. And I think what you're getting a picture of is people are saying that this could lead to harms to officers, the current situation. But what you're hearing is actual harms visited upon actual families today by the status quo, and a bill that, instead of addressing the issues that families are facing and getting access to the information about what's happened to their loved ones, we're getting a bill that takes us back in the other direction and just implements more secrecy on top of the secrecy that honestly already pervades too much of the policing. Thank you.
Members, any questions? All righty. Thank you for your testimony.
Thank you.
Chair calls Kirsten Budwine. Did I say that right?
Yes, sir.
Okay, I show you registered as Kirsten Budwine, testifying on behalf of Texas Civil Rights Project and yourself and against the bill.
Yes, sir.
All right, proceed with your
And
testimony.
because I'm the third person to come up here from TCRP, I'm not going to rehash anything that's been said already. But as an attorney, I was really concerned with the conversation that y'all were having with Mr. Grisham earlier about who would and would not have access to these documents. I find it really troubling to set a precedent that someone would have to hire an attorney to sue whoever has these documents in order for them to get access to it. As you've already heard from several witnesses, these documents are already extremely difficult to get under the PIA, the Public Information Act law. And I just find it really troubling. I had to come up here and say that as an attorney. I just find it really concerning that that's kind of where we're starting, and that's the precedent that we will be setting with this bill. And so that's what I want to limit my testimony to.
All righty.
Thank you.
Members, any questions? All righty. Thank you for your testimony. Chair calls Brian McGivern. How bad did I butcher that?
Well, I knew you were talking to me.
Okay. Okay. How do you pronounce it?
McGivern.
McGivern. So you registered as Brian McGivern, testifying on behalf of yourself and neutral on the bill?
Yes.
All righty, proceed.
So I decided to come here because I wanted to share a concern that I have with that the bill as it's drafted now, I think threatens to undermine some carefully crafted agreements that have been executed between municipal police associations and their municipality. I guess I should introduce myself. I'm an attorney. I'm the executive director of a group called the Austin Community Law Center. And over the last 9 years, I've had many reasons or many opportunities or many instances where I've reviewed the scope of Local Government Code 143, including .089G, but not exclusively. And I think that everyone can probably agree that there's at least some tension between the language in the proposed bill and 143. It says, the current bill says as provided by law, or as required by law, I think. And the language in 143 that permits these agreements, these collective bargaining agreements, to disclose information, it simply says that an agreement will preempt contrary state law. It doesn't specifically say anything about disclosing information from the G file. This creates some ambiguity. Now, as a practitioner, I contemplate, how would a judge look at this? Well, Government Code 311, the Code Construction Act, sets forth many principles for how to try to reconcile two statutes, because of course that's the goal, to try to make them both effective. Two of the principles in there, one which alarms me the most, is that when there is a conflict and you can't reconcile two statutes, the statute later in time prevails. One that gives me a little bit less heartburn, but is still concerning, is the principle that the more specific language, the more specific section of the code prevails over a general rule. Now, I understand, reasonable minds can differ on the interpretation. Members of this committee have, I'm sure, formed their own beliefs about how these two statutes would reconcile with each other, or how they should be. But I also think you shouldn't lose sight of the fact that there are 15 courts of appeals in this state and a whole mess of district court judges, any of whom could very well read this differently. And I understand that there are statements of intent within the legislative history, but I also know that in interpreting the law, the word of the law prevails first. Only in a moment where they cannot determine to their satisfaction, the meaning of the written words, will they look to parole evidence like statements in legislative history, which only have marginal benefit because one person may intend one thing, but who's to say that that is what every person voting on this within the legislature believed? And so, because of that, the way it is written, I do think that it threatens to undermine some of these agreements, both for officer access to additional information that they wouldn't necessarily have when they are subject to discipline, and to access by civilian review entities. So,
Thank you for your testimony. Members, any questions for this witness? Thank you for being here.
thank you for your time.
Chair calls Skylar Hearn. We show you registered as Skylar Hearn, testifying on behalf of the Sheriff's Association of Texas and for the bill. Is that correct?
That is correct.
All righty, proceed with your testimony.
Mr. Chairman, Vice Chair, members, on behalf of the Sheriff's Association, we are asking for your support for this bill. This is not a new concept. For more than 20 years, the state legislature has provided statutory coverage to certain municipal police officers and all DPS officers, these same provisions, preventing public access to unsubstantiated complaints. That's about 26,000 officers around the state that currently have this coverage. Missing from that statutory coverage is every sheriff's office. Every county that y'all represent, there's not one deputy or one jailer that has that same coverage. That's 17,000 deputies, 25,000 jailers that would like the fairness of having what has already been the concept for more than 2 decades. A lot's been said, and I know your time is precious, so I will open myself up for questions if you have them. But for your deputies and your jailers in your counties, we ask for your support for this bill.
All righty. Chair recognizes Representative Louderback.
Scott, I appreciate you testifying today and bringing some clarity to a situation that seems to be, I guess, collectively misconstrued with some misinformation for some time. So in the deputy world, the jailer world, and in certain small cities and things, have we been looking for some consistency in this? And with consistency, doesn't that bring with it a degree of credibility that has been missing for the deputy and the jailer world in small city police departments or civil service? Aren't we trying to get to a point where we all have the same system that we're working under? Isn't that the best idea that we could have as far as policy?
Yes, I agree. And I think through y'all's help, we have done that over several sessions. One of the biggest things that y'all helped with was the sunset bill in the 88th session for TCOL, that prior to that bill, there was a loophole. An agency didn't have to complete an investigation. In fact, some agencies, chief administrators would bargain a resignation over a completed investigation, so somebody would just go away that was a problem. And as an administrator and a 32-year officer, we don't want bad officers either, right? So that fixed the issue of the gypsy cop and the wandering officer, and requires administrators to ensure that if there's any allegation of misconduct, I can't bargain that into a resignation, and if the officer decides to leave anyway, I still have to finish that investigation, so that any other agency that wants to hire that person knows everything that person's done, and there's some closure to that. And those incremental steps have got us to this point where it's only natural to make sure that everybody's working off the same coverage for when those same investigations determine them to be unsubstantiated. We should all have the same coverage statewide.
Thank you. Thank you for your years of service with the Department of Public Safety as a director, and thank you for your work with the sheriffs.
Representative McLaughlin.
First and foremost, thank you for your service, and I do support law enforcement, but I have to go 2 questions. One, so if we pass this bill, would TCO still be entitled to look at these files as
100%, yes, sir.
that they license that officer?
Yes, sir.
And the second deal to that question would be, again, I gotta go back to the Robb School shooting and so forth. In an incident like that, it's to your best interest as a law enforcement to lay the cards on the table for that day. Because until we get those answers, you still have a black eye in the public's eye.
Yes. Again, I think there's been lots of coulds and mights and mays applied to what people think this might be versus what it is. This does not affect criminal investigations or accusations of criminal misconduct or any of the associated work product of the agency that goes with that. Videos, case reports, all of that is covered under all kind of other locations. This is about the individual officer's document. This is not about the body-worn camera. This is not about the case report. This is not about the call logs from dispatch. All of that is governed separately and is held and maintained separately under different statutes.
Okay, thank you.
The only other thing I'd add, Mr. Chairman, is there's been several comments about independent investigation. That would be wholly untenable in the state of Texas, that somebody else has to investigate every complaint that comes in for 2,700 agencies. You would have to create 2,700 new agencies just to work complaints for all of that. It would just be
2,700
untenable.
times at least 3 to 5 to 7 people, whatever that committee would look like.
Yeah, it would be an untenable situation. It sounds good when you say it, having independent review, but with the volume of, again, unfortunately, a lot of people out there get their legal advice from TikTok and Instagram.
You don't
and they
say.
think they know their rights, and the bulk of those are just misinformed. They think they're right, but they're misinformed, and it spawns all these complaints of you didn't do this and you didn't do that, or you did this and you shouldn't have. And the vast majority of those are just unfounded and misinformed. And it would take a whole new agency to do an independent review of every complaint.
Okay. Representative Holt, then I'll come back to you.
Thank you for being here, and thank you for your service. I just have a real quick question. Approximately, how many complaints are frivolous or unfounded?
Based on statistics I've seen on researching it and my own 32 years of experience, 70, 80%.
Okay. Okay, and I did have a second question. Thank you for that. Use of force documents. Can you tell me where those lie? Are they like the body cam? They're
Separate, completely separate
Okay.
documents. They're they're government records. All of that is, none of this is commingled. It's
Okay.
all separate.
Okay. Thank you very much.
All right, Representative McLaughlin.
So I want to go back, and this is more of a statement than that, but it's been brought up that mayors should do the investigation and so forth. I was the mayor of Uvalde for 10 years.
Yes, sir.
I'm not qualified to do an investigation. I'm not law enforcement and so forth. I will say, though, that we did get complaints on officers, and I did require an investigation. It resulted in 3 officers losing their jobs.
Yes, sir.
We also had investigations where the officers didn't lose their jobs. But it's not mayors or civil people, because they don't understand the law enforcement world, that should be doing this investigation. And like you said, I don't think we have enough people that could fill those committees to do that.
Yes, and just from my background as a former Texas Ranger, one of the jobs the Rangers provide the state of Texas in rural Texas is that public corruption, public investigation, public integrity role. When you have that one-person agency or that two-person agency and that complaint comes forward, there is a law enforcement body that can be independent and come in and do that when that need arises. Yes, sir.
I was just going to ask that, so I'm glad you mentioned it. Members, any other questions? All righty. Mr. Hearn, thank you for being here. Chair calls Jennifer Szymanski. Show you registered as Jennifer Szymanski, testifying on behalf of Combined Law Enforcement Associations of Texas and for the bill. Is that correct?
That's correct.
All right,
I'm Jennifer
proceed.
Szymanski. Thank you for having me today, Chairman and members of the committee. I'm the Deputy Executive Director for CLEAT, which is the Combined Law Enforcement Associations of Texas. We represent 28,000 law enforcement officers across the state. I took a lot of notes because I don't want to repeat what's already been said, but I did want to clear up a few things, and I'm happy to answer questions. I think everyone understands now how we got to this language. I did serve on the committee that helped draft this model policy that we were asked to draft by the legislature. The commissioners voted for these policies after 6 months of working on those with a committee of stakeholders, sworn and non-sworn. I've been a sworn peace officer for 18 years, worked for the Attorney General's office, worked for the Austin Police Department, and then came over to work for CLEAT. With that perspective, I want to address some of the false narratives surrounding this bill and circulating the building. This is the prime example of why this legislation is needed. These same groups are the ones who seek to vilify law enforcement and smear officers ahead of any sort of due process. Too many stand ready to try an officer in the court of public opinion every opportunity they get. This negatively impacts the profession and law enforcement's relationship with the communities they serve. Going over a few of the things that were said. It was said that things like 911 calls, body camera, all these things, these are not part of the personnel file. Personnel files are only materials that are pertinent to, and it says it in the bill, to the officer or the license holder. Not 911 call logs, not body-worn camera. Those are not attached to the officer. So all those documents, and I think that was mentioned, are completely separate from this bill. One of the things that was said by the Dallas lieutenant made a really good point about the days off, that this could be used potentially against officers in their personal lives, which is a great point. However, another point there on days off, the early warning system that Dallas is wanting to implement and that all the other large progressive cities already have in place. We had it at the Austin Police Department. They have it in San Antonio, Houston. We have these early warning systems. Dallas can't have it right now because this would all be open to the public. And another trigger for those algorithms that identify the officers and the programs are days off. And another instance when days off sometimes can be alarming for a supervisor is if they are taken in conjunction with use of force or things that might indicate that they're struggling with their mental health. These are reasons why this algorithm and these early warning systems cannot be made public ahead of the supervisors investigating, pushing it up to internal affairs or whoever it is that's going to investigate. I think Representative McLaughlin, your response on the smaller agencies, that's exactly right. The smaller agencies do investigate. They absolutely do investigate. They can utilize the Texas Rangers, they can utilize the Texas Attorney General's office, and they do. And those investigations are required, as you stated. Those are required investigations by TCOL that is in state law. After the TCOL sunset bill, it is absolutely required that every head of agency complete a misconduct investigation on every allegation. That is now in state law. So the accusation that those just aren't happening, there is now oversight because of the legislature that TCOL has over all those files. They get to review them and ensure that the investigation did in fact take place, that it was thorough, and that the proper remedy was executed. Going into the in-camera inspection, this we disagree. The in-camera inspection, the district attorneys mentioned, or the one district attorney representative that's here mentioned, they want the entire file for criminal investigations pertaining to an officer. Well, that's not due process. The way it currently works is they get an in-camera review, and that's the way it should be. For example, we have Officer Taylor in the city of Austin who was just convicted of deadly conduct for doing his job. Prior to that, the system worked perfectly, and it was fair. And what it was he was working under 143.089G as an Austin police officer. There was a criminal case, and the judge in the case got to review the file, the departmental file, and determine what in that file was going to be released to the defense, or to the state in this case, for discovery purposes. That's how it should be. That's due process. You don't just get everything, regardless of who you are. As far as the comments that were made by the Harris County group, by the way, Combined Law Enforcement Associations also represents half of the Harris County deputies, the other half, who support this bill. Meet and confer contracts do not have any bearing on in-camera review. So for example, if a city comes into this law, if this law passes and you're not a civil service city, or let's say you're a deputy, you're not going to have a meet and confer contract, but you are still going to get an in-camera review in the event that there's a criminal case and a judge presiding over that criminal case. So we disagree on the meet and confer, that you need to have some kind of agreement to be entitled to that in-camera review. That's false. And we know because we represent officers on a regular basis who do work under these protections currently. The fact of the matter is police officers and the sensitivity of what they deal with daily should be handled the same regardless of which agency they work for. And that's exactly what this bill accomplishes. I'm happy to answer any questions if anyone has any.
Representative Pearson.
Thank you. Thank you, Ms. Mansky, for being here. I was actually hoping you were going to be here today. When the chairman laid out the bill, I asked the question, does this apply to every agency across the state? But I was hoping you were here because I specifically wanted to ask about Austin. The city of Austin does its own thing when it comes to police officers. And so what I want to know, if this bill passes, does this protect the officers in the city of Austin? Or do we need to do something additional? Or what is the way you were on the committee, what do you think this bill will do for the city of Austin?
So while I was serving on the committee, hands down, without a question, this would be, Austin Police Department was already covered by this when I was on the committee, and this bill absolutely would cover them.
Okay.
However, I will say this, that was September, that was in the interim from the last legislative session. After that, right before we came into legislative session, knowing we were going to codify this model policy, the Austin Police Association went to the table, meaning they went to the table with the city to initiate a meet and confer negotiation process. During that negotiation process, they made a deal. It's a back and forth negotiation. That's what negotiations are. And you can make deals. And they did. And they made a deal that is contrary to this. So the answer to your question from our perspective, and by the way, we still represent around 900 Austin police officers today, CLEAT does. Our perspective is that when this bill passes, they still have a contract because they signed off on it, their members, a meet and confer contract that is in place today. So as you know from other laws, when you pass a law, it doesn't supersede an existing contract. So we do believe that there may have to be some litigation. We absolutely want them to be covered by this. We absolutely don't agree that they gave this provision up as part of their negotiations, but they have every right to do that, and that's what they chose to do. We will work hard to ensure that they do come under this. Eventually, when their contract is up, they will absolutely come into this. But right now, they have a contract that they're going to have to deal with, whether that's through litigation or whatever that might be. We're here to support them, but there is going to be, with those officers, a small issue regardless of what happens.
Okay, that's what I
Does
wanted
that make
to know.
sense?
Yes, thank
Okay.
you.
Yes, ma'am.
So would it be accurate to say that in a meet and confer, you could disclose more
You can.
than what is predicted, but not less?
Correct.
Right, okay.
Correct.
Representative Louderback.
Thank you, Jennifer, for your service and for representing CLEAT the way you do. On this meet and confer that y'all had with Austin, there's a lot of factors at play here, aren't there?
Yes.
There are many, many reasons why they agreed to the conditions of this deal. So when Representative Pearson brings a question that she did, I think this bill would help in that regard to get back on track in so many ways. If we can solidify where we're going and bring the clarity and the consistency of what we have, which I've got to repeat that because it's only with that consistency that we can hope to advance on this whole thing. If we're still going in different directions on here and parties are not protected under this consistent model, we're simply going to be in a state of chaos so many places. So I think that this bill will help with recruiting. I think it'll help with the systemic loss of personnel that several of these things haunt law enforcement for years, and they have substantially been used to deplete our ranks. And so there's very few agencies out here in Texas that are not short of employees as we hemorrhage veteran officers every day. So these are things that, would you agree, that would be very beneficial for the industry of law enforcement?
Absolutely. Unfortunately, and I can say this as a former Austin police officer, unfortunately, many times when we come to the legislature, every session since I've been with CLEAT, we come here in an effort to, in some of our legislative package, to prevent things that are happening in Austin from happening anywhere else. And that's how we ended up here. So again, we want them to come under these. We know that they will eventually, and we hope it's sooner rather than later. But we absolutely, as the sheriff said, as Representative Lauterbach said, we absolutely do not want this to occur anywhere else.
Thank you.
Representative McLaughlin.
Thank you again for your service. And again, I'm not against law enforcement. I just want to make sure that we're not closing a door that shouldn't be closed.
Yes, sir.
But as outlined on this bill, subsection C, section 1701, 45351, I would specify that a department file must contain, and I quote, a letter, memorandum, or document relating to the license holder not included in a personnel file, including any of the 3 listed items regulated to alleged misconduct for which the agency determines there is insufficient evidence to sustain the charge of misconduct. What is the definition provided in statute of any of document?
Any document inside of a personnel file?
Or what is the definition provided in statute of a document, or what they're considering a document?
So it would be, as the chairman explained, it would be anything that is not in the personnel file, and those are listed specifically. So, but what I'm trying to get at, and what I was trying to get at earlier, is that that doesn't include a lot of the things that have been mentioned today that are more departmental wide, like body worn camera, 911 call logs, those things. Those are not included. I think what you're asking is what else might be in there, and I wanted to get into that. There are background investigations that are currently open to the public for agencies that are not 143. Now, are they redacted? Yes, but political subdivisions are constantly requesting opinions from the Attorney General's office, and in many cases then subsequently suing the Attorney General's office because it's simply not proper what we are required as a political subdivision to release for these at-will agencies. It's, for example, background investigations. Currently, I'm a city council member in a smaller city around here, so I have a different perspective as well on this, meaning I've seen the other side from the city side, as you have. It's disturbing what we are required to release on law enforcement officers and their families. Currently, the only thing that's redacted per the AG, and he's only going off of 552, is the PII, the personal identifying information. That's it. Everything else that we provide in our background investigations, which goes, as many know in this room, way in depth on our family members, any encounter that they've had or we've had with law enforcement. Many of the times we're okay with releasing things on the officer. It's on their backgrounds because we're proud of who we hired. We wouldn't have hired them if there was something in there. However, their family members, that information absolutely should not be released to the public. Another thing that's in there that hasn't been discussed today, I think I discussed it in the last committee hearing, are coaching reports. They're called counseling, they're called different things in different training memos, different things in different departments, but it's how we train officers. So it's supervisory notes, I think someone said earlier. Those are things that we need to be documenting, and we do. I was a patrol supervisor when I left APD. We do document those things. But in Austin, they're all protected unless it's a substantiated investigation. So we're talking about things that you do when you debrief a new officer on a call and you say, you need to do this better. These are some recommendations. All those things, we want law enforcement to document those. But this is a gray area here when supervisors, let's say in a sheriff's department, know that all that is going to be open to the public. Do you see where that's potentially an issue? I mean, you need to be able to document that knowing that it's confidential unless it rises to the level of an internal affairs substantiated misconduct.
And I would agree with you on that, keeping that confidential. And I do believe a background check, other than what pertinent information be there, any family information should be redacted and never released, because so many of these officers have to deal with that today.
Yes, sir.
So I
Thank
do
you.
agree with you on that.
All right, members, any other questions? All righty, Jennifer, thank you for being here.
Thank you.
Is there anyone else wishing to testify on, for, or against Senate Bill 15? If not, okay, that'll end our public testimony. And then I will close on the bill. Members, again, this is a bill that will standardize and make consistent statewide practice regarding personnel files. I want to remind everyone there was an interim study that was authorized by this legislature last session. We instructed T. Cole to go out and come up with a model policy that would apply statewide to have a consistent statewide model. That was made up of prosecutors, defense attorneys, people from the public, police, and law enforcement officers. They went to urban areas, rural areas, large and small cities all across the state to come up with this. This wasn't just something that one certain group or somebody dreamed up. This was a working group that went all over the state and had lots of input. 26,000 police officers already operate under the provisions of this bill. TCOL will still have access to these files, as well as any hiring agency that's looking at these officers. So with that, if there are no questions, I'll close. I know during the regular session, we typically leave these pending for a little bit of time, but I'm going to go ahead and take a vote on this bill and move it through the process if the votes are there. So with that, the chair moves that Senate Bill 15, without amendments, be reported favorably to the full House with a recommendation that it do pass and be printed. The clerk will call the roll.
Chairman Hefner,
Aye.
Vice Chair Lopez,
Nay.
Canales, Cortez, Isaac, Durazio, Lauterbach, McLaughlin,
Can I make a statement as a vote?
Sure.
I just want to say to the public that I don't want to vote for a bill that gives any law enforcement agency authority, whether directly or indirectly, to hide files related to a mass casualty. Excuse me. If this bill allows that anyway, I would be voting no on the floor. However, I will vote yes to take it out of committee.
Representative Holt. Yes. Representative Pearson. Aye. Representative Hicklin.
There being 7 ayes and 1 nay, the motion prevails. Members, is there any other statements or comments you'd like to make? Where's my closing stuff? All right, if not, members, that includes today's agenda. Is there any further business for the committee to address? If not, the chair moves to adjourn. Is there objection? Hearing none, the committee stands adjourned, subject to call of the chair.
Chair lays that on second reading, Senate Bill 15. The clerk will read the bill.
SB number 15 by King, relating to certain files maintained by a law enforcement agency regarding certain employees of the agency.
Chair recognizes Mr. Hefner to explain the bill.
Thank you, Mr. Speaker. Members, certain information related to a peace officer should be disclosable to the public, and certain information should not be disclosed. Unsubstantiated complaints of peace officer misconduct, in particular, should not be released to the public. Right now, there is no consistency among law enforcement agencies regarding what files are made public and what files are not made public. Civil service cities, which are those that have adopted Chapter 143 of the Local Government Code, currently maintain both a separate personnel file and a department file for every officer. Some of those cities are like Tyler, Lubbock, Fort Worth, and some others. Chapter 143 requires the following documents to be held in the personnel file: substantiated misconduct complaints, commendations, congratulations, or an award bestowed on the officer, and periodic evaluations of the officer by a supervisor. All other documents not required to be held in a peace officer's personnel file must be held in their department file. This would include unsubstantiated misconduct complaints against an officer.
Mr. Speaker.
Speaker Moody, for what purpose?
Will the gentleman yield for some questions?
Gentleman, yield for questions.
Not at this time. I'm
Not at
almost
this time.
finished. Other things that would be in the department file are complaints that did not result in disciplinary action, training memos, counseling, and other coaching documents, and background hiring information. Some of that background hiring information could include family information, the officer's education, where they've lived. We've even seen instances of where their family's mental health was exposed to the public because it was in this file, and any family interaction with law enforcement officers. So in response to a recommendation by the Sunset Commission, TCOL commissioners adopted a model personnel department file policy for all law enforcement agencies that substantively mirrors the requirements of Chapter 143 Civil Service Cities. All Senate Bill 17 does is codify this model policy to prevent any conflict with current law. And I'll yield for some questions.
Mr. Speaker.
Speaker Moody, for what purpose?
Will the gentleman yield for some questions?
Gentleman yield for questions.
Sure.
Gentleman yields.
Thank you very much, Mr. Hefner. I want to focus on the back end of your layout as you describe the documents that would be contained within the newly defined department file. So that's essentially what the bill does, right? You are creating a department file and directing certain documents over to the department file.
Yeah, so
as opposed to the personnel file.
Right. So currently, there's about 26,000 officers across the state of Texas that already operate under the provisions of this bill. And those guidelines came from the Sunset Commission last session, where we advised T-Cole to put a committee together, a working group, if you will, of law enforcement officers, civilians, attorneys all across the state to put together best practices for the storage of personnel files. And yes.
And so you're not doing anything to change the definition of personnel file?
No.
So in the occupations code is where we have the current definition of what can be held in the personnel file, correct?
I'm not advised of where it's spelled out, what could be held.
Okay, no, then
in the
that's fair,
personnel file.
but it's codified somewhere, right?
Yes.
Okay, and I think you may have mentioned in your opening, there's certain things that are legally required to be in there, personnel
Correct.
file. What were those again?
So some examples of those are substantiated misconduct complaints, commendations, congratulations, awards, periodic evaluations of the officer by a supervisor. Those are some examples.
Got it, okay. That's not changing under the terms of your bill, that stays over there, personnel
Correct.
file, right? We have a new department file. In your layout right now, you mentioned some things that would go into the department file under the bill. Now, unsubstantiated claims is number one on your list, but you listed off a whole nother category of things. So you talked about background hiring information. What is your vision of what that includes?
Well, I mean, when an officer is hired, I've had some personal experience at this where that hiring agency will do some background research on that particular candidate to be hired. And so they could go back and look at things in that officer's history. They're going to interview their family members' interaction with, past interaction with law enforcement. And we have a real life example of where an officer's wife's mental health issues were exposed because of this being open to the public. And so we don't believe that is appropriate for information such as that to be released.
No, and I get what you're saying. I'm just trying to get my arms around what's going into this newly created department file other than unsubstantiated claims. So some of this family history interaction with law enforcement would be in there, in your understanding?
Yeah, and it would be
their educational attainment?
Their educational background, where they've lived, training memos, where they've been coached, where maybe they could have done something a little better, but
Okay.
it didn't rise to the level of any disciplinary action, counseling, any other document that's not statutorily required to be placed in the personnel file.
So any other document, and that's why I was looking at your bill, any other document, because the language on page 1 of your bill, page 1, line 13, must contain any, this is what you're talking about, any letter, memorandum, or document relating to the license holder not included in the personnel file maintained as required under the definition. So the things we talked about, the commendations, the awards, the disciplinary actions, the things that are statutorily required in the personnel file, your bill says anything that's not that needs to go in the department file. Is that how it is?
Yes, but there are some things that are managed and policed by other codes in the law.
Mm-hmm. No, so I'm trying to gather what it is
where
we
you're
envision,
headed.
because you got two different buckets essentially, right? And we have one that's defined under personnel file, and then you're creating a department file where the way I read this is Anything else that's not required to go over here needs to be in the department file.
Yes.
Okay, all right. Just wanted to drill down on that. Thank you very much. I appreciate your time.
Yes, sir.
Mr. Bryant, for what
Mr.
purpose?
Speaker, will the gentleman yield?
Gentleman yield for questions.
Yes.
Gentleman yields.
Mr. Hefner, in the last section of the bill, subsection G, it says that a law enforcement agency may not release any information contained in a license holder's department file to any other agency or person requesting information relating to the license holder, that is, to the law enforcement officer. Would that mean also that the district attorney could not have access to that?
No, sir. That if you'll read the first sentence, it says except as provided by subsections D, E, and F. So any kind of criminal investigation or lawsuit would still have access to these documents.
Thank you.
Are we finished? We have amendments, don't we? Okay. I want to stress that SB 15 only affects requests for disclosure under Public Information Act. Something we just covered here. If someone is suing a law enforcement agency or officer, they will still have access to the documents in the department file via discovery as required by law. This is true for a prosecuting attorney attempting to access files to press criminal charges against an officer, defense counsel, and other police agencies. Additionally, this bill will not affect disclosure requirements under the Michael Morton Act and the Sandra Bland Act. Senator King accepted an amendment on the Senate floor that clarifies for the purposes of accountability and transparency of those specific acts. And I believe we have some amendment.
The following amendment, the clerk will read the amendment.
Amendment by Collier.
The chair recognizes Ms. Collier to explain the amendment.
Thank you, Mr. Speaker. I appreciate the dialogue that Speaker Pro Tem Moody and Chair Hefner just had, because that actually goes directly to the purpose of this amendment. We heard from the Chair Hefner that this amendment does not impact Chapter 143. And so regarding the records for the personnel file versus the department file, all this amendment does is clarify that there is no impact to Chapter 143, and that anything that is deemed to be confidential will remain confidential. The concern that I have is this bill is pretty broad, and so it could unwittingly sweep in dash cam video, use of force reports, and so I want to make sure that those documents would remain subject to disclosure if they need to be released. So say, for instance, somebody files a complaint against an officer, a law enforcement officer, for use of force, and it was found not to be substantiated. Does that mean that that report or that dash cam video is not subject to disclosure? We want to make sure that it's still available and it doesn't get swept into this bill unknowingly. So it just narrows the bill to the legal framework already in place in Chapter 143. And that's what this bill is modeled at. So this doesn't, it just provides additional clarity, so that way there's no question about what documents or information is subject to confidentiality under the department file. We want to make sure that the public still has access to this information, even if it's a part of a complaint that was found to be unsubstantiated. So there is a purpose in being able to have access to that, because it may not have to do anything with the actual complaint that's filed against the law enforcement officer, but it may have something to do with the public's need to see it. So That's all that this amendment does. It just narrows it to make sure that it's very clear that this bill only applies to the department personnel file. That's what it adds. And that way, the records that are currently public would remain public, because we want to make sure that the public has accountability and transparency, and we want to make sure that we're not limiting access to certain documents that would commonly be released. And with that, I move adoption.
Chair recognizes Mr. Hefner to speak against the amendment.
Thank you, Mr. Speaker. Members, this would basically undo the bill. There's a reason that we have department file defined and personnel file defined. And so
Mr. Speaker?
we feel like we
Ms.
have
Collier, for
struck
what
a
purpose?
balance between
Just when he finishes.
accountability and transparency. We think this bill does that in a good way.
Mr.
Ms.
Speaker?
Collier, for what purpose?
Chair Hefner,
Would it,
will
do you want the gentleman to yield for questions?
Yes, sir.
Does the gentleman yield for questions?
Yes.
Gentleman yields.
Okay, so my question surrounds whether dash cam video would still be subject to public disclosure, even if it is part of a complaint that has been filed by the public against an officer, and that complaint is deemed unsubstantiated.
So dash cam footage we're not affecting that in any way in this bill. Dash cam or body cam footage is maintained and I keep saying policed. That's not, I don't mean that, but it is governed by its own section of law, and we're not affecting that in any way.
Okay, so the reason why I'm concerned is that your definition does not explicitly state what you're telling us, and so I'm just trying to get it included into the bill to make sure that what you say, what you mean it to.
Yeah, but what the bill says is that any document or record not required by law. So anything that is already policed by or governed by existing law, we're not changing. So
Okay.
body cam footage and dash cam footage, we're not touching in this bill in any way.
And what about use of force reports?
Use of force reports. I mean, there's the complaint process that is spelled out in the TCOL recommendations, and whether or not if they're substantiated, they will go into the personnel file and be open to public view. But if they're unsubstantiated, they would not be viewable to the public.
So does TCOL require all complaints regarding use of force, whether they're substantiated or not, to be reported?
Yes, they do. There was, in that same study that was done from last session, the TCOL established the state of Texas model policy on misconduct allegations. So every agency, large and small, no matter how big or small they are, is required to report every complaint to TCOL, whether they're substantiated or unsubstantiated.
And in that reporting, does TCOL collect the name of the officer?
Yes, to my knowledge, they collect all the details spelled out in the complaint.
And the information that is collected from TCOL, do they differentiate between whether the complaint was substantiated or not?
Yes, because because of the two files. I guess they would determine if it's substantiated or not, and then where that record would be kept.
Well, I'm talking about the TCOL. So the TCOL is collecting the use of force complaints, right?
Or all complaints.
Okay, and you're saying that they're collecting complaints whether they're substantiated or not. So they're not saying, oh, well, this one was found not to be a violation, we're going to remove it. They're just collecting all.
They're going to keep it, and they're going to have a database that's going to maintain all records of all complaints filed. Whether they're substantiated or not, they're still going to keep that complaint and the records of that complaint in a database.
But in their database, do they say this one was filed against Officer John Doe or Jane Doe, and it was found not to be substantiated?
I can confirm that, Representative Collier, but I'm fairly certain that, yes, it would contain the officer's name and all the information related to that complaint.
So then why is it that this information would not be part of that officer's file if it is also being reported to TCOL?
Well, the purpose of that is to keep people from outside that may be politically motivated or maliciously motivated to defame or discredit that officer. So some things need to be disclosed to the public and some things do not. And we've seen the department files, the information that are in these department files used to defame an officer or to discredit his integrity when he might have just been coached, he might have made a small mistake, or she, absolutely. And so we don't want those to be used. And we want agencies to be free to coach their officers and make them better, to teach them and coach them up and make them without fear of those items of coaching or whatever information they could have tweaked and done better without that being used against that officer. But if it is substantiated and it rises to that level, then absolutely the public should know.
However, my concern is that if it is in the records of TCOL, why are you trying to hide it in the department file?
Well, like I said, these things are not necessarily hidden. They're still available through lawsuits or criminal investigations. And so there should be a due process and an exhaustive process to go through to gain access to those should the need arise.
And what is that process?
Well, there can be what they call an in-camera review by a judge, where a prosecutor can ask that judge to look into that file and determine whether the information in that file should be released to the public or not. So it's checked by a judge.
And would that process still be applicable under your bill?
Yes.
So you're saying that the department file would be subject to open records request?
No.
It would not? Okay.
It would not be. So there would have to be some sort of other circumstance, a lawsuit or criminal investigation, or a judge would have to decide that those things were available to the public.
But you're not sure if this information is also available through TCOL?
TCOL keeps it all.
They have it all?
Yes.
And you're not sure if the public has access to that?
I'm pretty sure they would not.
Okay, so it's your position that this bill does not change what is a personnel file under Chapter 143?
Correct. And I'll need to clarify that in-camera review for the judge would only be for him to determine whether it could be released via discovery,
of course.
Not necessarily released to the public.
Okay, absolutely. And so for this amendment, what is your position, that it goes too far or it doesn't mimic what
I have a definition of department file and I have a definition of personnel file, and you're putting personnel everywhere.
In between.
And I think it kind of just clouds the two separate files.
Would you be open to having some type of language added that clarifies specifically that this bill does not change what is disclosable and confidential under Chapter 143? Because that's all I'm trying to clarify.
No, we believe that language is already clarified in the bill where it says not otherwise required by law. And so all those other laws remain.
What are give me the names of all the laws then. What are you talking about? I mean, that's
applicable
how vague
laws.
your bill.
You can't name all the laws in the code either, but anything that's not included here in this bill.
Well, that proves my point, that that's how vague the bill is.
No, it's not vague. It says certain things that are not required by law are then kept in this department file.
But can you tell me what the notwithstanding any other law is? Because we just need
Well,
to
for
know.
example, the body cam footage, which would still be subject to whatever laws it falls under currently. So we're not changing that. So that's one example.
But Chapter 143 is another example that you're saying that you're not changing. Is that right?
Chapter 143, we're just taking Chapter 143 and applying it statewide. 26,000 officers in this state already operate under provisions of 143. They're called civil service cities.
But I'm concerned that your bill goes beyond Chapter 143.
It does not.
And that's why I'm asking you. And
It
with
does
that
not.
broad statement, notwithstanding any other law, it could be misinterpreted or misconstrued to mean other laws that you never intended. So I'm just trying to get for legislative intent.
No, we're taking
notwithstanding
143,
other-
we're copying
I'm
and
sorry,
pasting it.
can I finish my question?
Yes.
I'm trying to establish for legislative intent the notwithstanding any other law. What does that reference, and what is it that you mean by that? And it sounds like Chapter 143 is one of those, but what are the other laws that this is not treading over?
What we're doing is we're not changing 143. We're taking 143 and we're applying it
The gentleman's
statewide.
time has expired.
Mr. Speaker,
Ms. Collier, for purpose.
I move for extension of time.
Members, you've heard the motion. Is there objection to the adoption of the motion? Chair hears none. The motion is adopted. Time is extended.
So I just want to make sure again, let's go back to that section, because this is for legislative intent. So you said that your bill says notwithstanding any other law. And let's go by, can you show me what line that language is on?
Yeah, I've read it. Give me just a second. One place you could look is page 2, line 7. It says, any department file maintained under this section is subject to disclosure only as required by law.
I'm sorry, what page?
Page 2,
Okay.
I believe,
And
line 7. That's one place it says that.
What line was that?
7.
Okay. A department file maintained under this section is subject to disclosure only as required by law, including Chapter 2B and Article 3914 and Section 511. All right? Are those the only ones?
No, it just says including.
Okay, so can you tell us what the other ones are?
No, I'm not advised on all of them, but
Well, I mean, you want them to comply with your law, right?
you're sitting here saying when I say it's required by law, I'm supposed to know every law on the books? That's crazy.
Is it?
Yeah.
Well, I mean, you wrote the bill. I'm assuming what your intent is. I'm just trying to figure out what it is.
I just told you what my intent was.
Is it only
It
these?
is not to conflict with other laws. I mean, this is taken, Chapter 143, which is current law. It is being used by 26,000 cops, law enforcement officers in this state currently, and it applies a consistent framework statewide so that we don't have a mix and match hodgepodge of managing records across the state.
Okay, so in terms of what would be included in this department file that's not subject to disclosure, if there is a document that would be in a publicly displayed, would be open to disclosure, but also could also be included in this department file, which one prevails? Would it be disclosable, or would it be confidential? Because if there's a conflict.
If it's required by law to be disclosable, it's going to be in the personnel file.
Even if it overlaps with this bill?
I mean, I think the prevailing rule would be to be disclosable to the public. I mean, I don't think there's going to be a law that's going to say it could be in both. It's going to be, if it's either disclosable to the public or it's not.
Okay, and so if there's a conflict, what I just heard you say, it would be, you would err on the side of disclosable. Is that right?
I mean, I would assume.
Is that a yes?
I would assume.
I'm sorry.
I would assume that would be the case.
Okay, Mr. Speaker?
Ms. Collier, for what purpose?
I move to have the discussion on SB 15 reduced to writing and placed into the journal.
Members hear the motion. Is there objection to the adoption of the motion? Chair, is the motion is adopted.
Move to table. Members, I move to table this amendment.
Chair recognizes Ms. Collier to close on the amendment.
Where to put that thing?
Okay, members, so this amendment is trying to provide clarity that we want to make sure that dash cam footage or use of force reports that are commonly released by agencies are not personnel documents that would not be subject. So I appreciate the discussion when there is a conflict between whether it's disclosable or not. The bill author has suggested that those documents be disclosable. So that does provide a little bit of added comfort, but it would be better if it was actually reduced to writing and in the statute to make it clear that this bill does not change Chapter 143 and that it works in conjunction with Chapter 143, because I'm concerned with some of the broad language. And I don't believe that this changes the bill at all, so I would move that you vote against the motion to table.
Members, Ms. Collier sends up an amendment. Mr. Hefner moves to table the amendment. The question occurs on the motion to table. If you support the amendment, vote nay. If you oppose the amendment, vote aye. The clerk will, record vote has been requested. The clerk will ring the bell. Show Mr. Bojani voting nay, Mr. Alders voting aye, Mr. Hefner voting aye, Mr. Verdell voting aye. Have all members voted? Have all members voted? There being 85 ayes and 53 nays, the motion to table prevails. The following amendment, the clerk will read the amendment.
Amendment by Manuel.
The chair recognizes Mr. Manuel to explain his amendment.
Thank you, Mr. Speaker and members. All this does is make sure that we're protecting from racial profiling here in Texas. This amendment right here, what it will do is make sure that if there is a law enforcement officer who has had any form of discrepancies when it comes to race or looking at someone outside of that, that we would have this into the G file, which would mean that it would stay in the public atmosphere so that we can look at this if there's a need. Yes, some people will say not all police are bad, and we know that not all police are bad, but we do know that there are always bad actors someplace. And we need to have these protections to make sure that people are protected from being racially profiled in our police department, especially with our tax dollars. I really hope that you will support this amendment and very much appreciate you all for listening.
Chair recognizes Mr. Hefner to speak against the amendment.
Thank you, Mr. Speaker. Members, I appreciate Representative Manuel, his intent here, but I believe that this situation will be covered under our normal practices and procedures about these complaints being filed, and the process would work out where these files should be or not be. So I respectfully ask y'all to help me table this amendment.
Chair recognizes Mr. Manuel to close on the amendment.
Thank you all. If we already think that it's in the bill, how about we just make sure that it's in the bill so that we don't have to deal with this someplace in the future and increase our tax dollars? Because every time someone ends up being liable for one of these that's a police officer, we end up having to pay that from our cities, from our counties. And then guess what? We just passed a tax bill saying we don't want to increase people's tax dollars, but you're now going to open them up to liabilities, which is insurance. I would really appreciate your support on this. Thank you all. And Mr. Speaker, I close.
Members, Mr. Manuel sends up an amendment. Mr. Hefner moves to table the amendment. The question occurs on the motion to table. If you're in favor of the amendment, vote no. If you're in favor of the amendment, vote no. If you oppose the amendment, vote aye. The clerk will ring the bell. Show Mr. Hefner voting aye, Mr. Manuel voting no, Mr. Bojani voting no, Mr. Leach voting aye, Mr. Bernal voting nay. Show Mr. Paul voting aye. Have all members voted? Have all members voted? There being 83 ayes, 56 nays, the motion to table prevails. The following amendment, the clerk will read the amendment.
Amendment by Gonzalez of Dallas.
The chair recognizes Ms. Gonzalez of Dallas to explain the amendment.
Thank you, Mr. Speaker, members. This amendment is meant to recognize the seriousness of abuse of office offenses detailed in Chapter 39 of the Texas Penal Code. When allegations of criminal activity are made against those responsible for enforcing our criminal laws, the government owes a duty to investigate and be transparent with the public, the public they are entrusted to serve. At the same time, our law enforcement officers should never be targets of complaint filers who abuse the system for personal gain or attention or personal vendettas. Our state legislature, at multiple points in its recent history, took action to prove to the public that crimes committed by public servants under our state seal or under the seal of local governments deserve prosecution and punishment. Each offense and alleged offense should be taken seriously and investigated thoroughly by every branch of local and state government. The offenses organized under Chapter 39 of the Penal Code are abuse of official capacity, official oppression, violations of civil rights of a person in custody, improper sexual activity with a person in custody or under supervision, improper sexual activity with a committed person, failure to report death of a prisoner, and misuse of official information. Multiple allegations of these offenses against the public should be information that the public should have access to if they request it. Private information should obviously stay private. There's no debate about that. This amendment says that repeated allegations of misconduct could mean a pattern of behavior and a pattern of failure to hold officers accountable by departments. And so, to me, there's no justifiable reason to keep this information from the public. I think it's important, and I think that we can all agree to that. And so, I move adoption.
Chair recognizes Mr. Hefner to speak against the amendment.
Thank you, Mr. Speaker. Members, again, these are provisions of Chapter 143 that have been in the code for decades, and it's worked to work out these complaints, and so I think we've got a bill here that properly balances accountability and transparency, and so I respectfully ask you to vote with me to table this amendment.
Chair recognizes Ms. Gonzalez to speak and to close.
Members, look, again, I'm not sure why somebody would want to protect bad actors these folks are supposed to be protecting the public, not abusing it. And so I urge you to not vote in favor of the table of this amendment. Thank you.
Members, Ms. Gonzalez sends up an amendment. Mr. Hefner has moved to table the amendment. The question occurs on the motion to table. If you support the amendment, vote nay. If you oppose the amendment, vote aye. The clerk will ring the bell. Show Mr. Hefner voting aye. Show Mr. Hayes voting aye. Mr. Leach voting aye. Show, have all members voted? Have all members voted? There being 83 ayes, 56 nays, the motion to table prevails. The following amendment, the clerk will read the amendment.
Amendment by Bernal.
Chair recognizes Mr. Bernal to explain his amendment.
Thank you, Mr. Speaker. Members, look, I think that it's important to point out that just because we oppose the bill or have amendments doesn't mean that we're anti-police. I think that it's important to put that aside. In fact, my daughter had a birthday party this weekend, and there were police there as guests, right? So you have to understand that when you have a tremendous amount of power, there has to be some accountability. And one of the biggest challenges here is that we're taking the tools that we have to create accountability and putting them into almost an untouchable black box. And only people of means, only people who can afford it, can access that box, because the only way to get to them is to file a lawsuit. And that creates an imbalance, because folks who might need to figure out whether or not they have a case, they might need to investigate a little further, we're taking those tools away. And so what my amendment does is create what I think is a middle ground. Now, I know that the open records part might go away under the bill. That's why I'm going to vote no. However, what my amendment does is create an exception for pre-suit depositions. A pre-suit deposition is a tool that people can avail themselves with that would allow them to access relevant information, but prior to filing a lawsuit, which I think is a standard that is too high and creates an unfair balance. So with that, I'll move adoption.
The chair recognizes Mr. Hefner to speak against the amendment.
Mr. Speaker, members, thank you. This is kind of goes contrary to what the bill's intent is. We are trying to prevent fishing expeditions to go in and go through this file to use things that are unsubstantiated to defame or sue an officer. So with that, we feel like our bill strikes the right balance again, and I ask you to vote with me to table this amendment.
Chair recognizes Mr. Bernal to close on the amendment.
Thank you, and I appreciate the perspective and tenor of the bill author, but there is a word he used that I think gets to the heart and the point of what I'm trying to say, which is this word unsubstantiated. Well, who decides whether something is or isn't substantiated? That's the whole point of this exercise, is to create an environment where there's a neutral arbiter as to what is or isn't substantiated. But if it's just take our word for it, and the only way that you can avail yourself to your own rights is to have money to file a lawsuit, that doesn't make sense. That's not right. Again, you can be pro-police and believe that there should be accountability for the few that may act in a bad way, or have access to the information that exonerates them, not just in their own eyes, but in the eyes of the public. Thank you. Move adoption.
Members, Mr. Bernal sends up an amendment. Mr. Hefner moves to table. The question occurs on the motion to table. If you support the amendment, vote nay. If you oppose the amendment, vote aye. The clerk will ring the bell. Show Mr. Hefner voting aye, Mr. Bernal voting nay. Have all members voted? Show Mr. Alders voting aye. Have all members voted? All members voted. There being 81 ayes, 56 nays, the motion to table prevails. The following amendment, the clerk will read the amendment.
Amendment by manual.
The chair recognizes Mr. Manuel. Oh, there he is. To explain your amendment. Come on down.
Thank you, Mr. Speaker and members. This amendment is simply to make sure that we're protecting the community boards with policing, to make sure that they're not going to be able to be taken out, so that if there are incidents, they can go there. They can make sure that police are doing what they're supposed to be doing. We don't want them to lose faith in their communities, in the communities that they're being policed by. We don't want to take that away from them. We all know that sometimes there's distrust with the police departments. Taking away these kind of boards, making sure that they're not strong enough, that has real harm. And we're going to do that to people who put their lives on the line to keep us protected. I think we need to make sure that civilians and police officers are feeling together and entrusted. That's the point of this amendment. I really hope I can get you all support on this, and it's not just going to be a shoot down by party line vote. Communities deserve police who know them, and police deserve communities who know them as well. Thank you.
Chair recognizes Mr. Hefner to speak against the amendment.
Thank you, Mr. Speaker. Members, this just kind of defeats the whole purpose of having these two separate files. We're trying to maintain a consistent framework across the state that's been used for decades by many officers, 26,000, and we already have a complaint process in place. And so this would kind of go contrary to that. So ask you to vote with me in tabling this amendment.
Chair recognizes Mr. Manuel to close on the amendment.
Thank you. I don't think that it would cause any problems. And if we're talking about a framework, I just hope everyone realizes, do you want the same police in the cities that you have in the rural areas, in the suburban areas? I think we don't want to do this. I think this is going to be something that we will truly regret. We need to make sure that the communities, our communities, have the same faith in the police that we want the police to have in us. And by disbanding these and taking that chance, we are going to erode away that trust at the police. And I don't think any of us want that. I close, Mr. Speaker. Thank you.
Mr. Manuel sends up an amendment. Mr. Hefner moves to table the amendment. The question occurs on the motion to table. If you're in favor of the amendment, vote nay. If you oppose the amendment, vote aye. The clerk will ring the bell. Show Mr. Alders voting aye, Mr. Hefner voting aye, Mr. Manuel voting nay. Show Ms. Leo Wilson voting aye. Have all members voted? Have all members voted? There being 82 ayes, 56 nays, the motion to table prevails. The following amendment, the clerk will read the amendment.
Amendment by Moody.
Chair recognizes Speaker Moody to explain the amendment.
Thank you, Mr. Speaker and members. I'm going to talk about subject matter that we've actually visited about multiple times on this floor. And we've gone to great lengths to make sure that we were closing an unnecessary and unintended loophole in our Public Information Act. And that's what was known as the dead suspects loophole. Right? The dead suspects loophole, I'll just describe it for you. It was actually, the statute was born from something positive. It was saying if someone isn't convicted or if they're not placed on deferred adjudication, then those records are not going to be shared. All those records won't be shared with the public. They're not subject to public information. That's to protect the accused, right? If they're not convicted and they're not placed on probation, then those records shouldn't be in the public sphere, right? Then because that creates some sort of penalty for them outside of the law. What ended up happening, though, was that exception to public information started being used when individuals died in law enforcement custody. So I'm going to give a couple of examples so you can understand what I'm talking about. Because if you die in custody, you're not going to be convicted and you're not going to be placed on deferred adjudication because you are dead. And so agencies and entities started shielding records to protect themselves using what we now know as the dead suspects loophole. In a prior session, we passed a bill that closed that and said that we're not going to permit the abuse of that particular section anymore. What SB 15 does now, however, is it reopens that loophole, and it does so through this department file. And specifically, on page 2 of the bill, it says, page 2, line 16, a department file maintained under this section is confidential and not subject to disclosure under Chapter 552 of the Government Code. That's the public information statute. When we changed the access to records under the dead suspects loophole, we changed Section 552. And so what my amendment does is it preserves what we did prior to this, which was closing that very loophole, and that's all it does.
Mr. Speaker.
Mr. Little, for what purpose?
So gentlemen yield for questions?
Gentlemen yield for questions.
Yes, sir.
Gentleman yields.
Speaker Moody, Chairman Hefner's got a very important bill here, but I'm convinced that you also have a very important amendment. And the reason I'm suggesting that is as I understand what you're trying to do, is you're trying to carry forward the closing of a loophole from another session past. Is that right?
That's correct. Yes, sir.
Okay. And as I understand it, thank you for explaining it to me earlier. As I understand it, in the past, law enforcement could hide certain documents related to certain events because that suspect became deceased or incapacitated. Is that right?
That's right. And the practice of that was becoming more and more prevalent.
And so the previous bill that was passed, I think it was in the 89th, it was recodified here under House Bill 1620. The previous bill closed that loophole, but it seems to me that you're concerned that this bill could be used to create another loophole for the same information. So rather than just saying this information is not subject to disclosure because it involves a deceased or incapacitated person, now we could take that same information that was previously part of a disclosure loophole and put it in a new loophole as a department file.
Correct. Yeah, you're creating another place where that loophole can be exploited. And by the terms of the bill, the department file is not subject to Chapter 552, which would completely vitiate everything that we've done before.
So what I'm understanding your amendment is doing is you're taking that loophole and closing it once again, saying, hey, you remember this information about deceased people, you can't hide it in this department file either.
Correct. Yes, sir.
Did I accurately state that?
You did. Yes, sir.
Okay. And are there any real-life examples that you can think of where this type of information has been obscured under a previous loophole?
Well, I think the most prominent example that people could wrap their minds around, because we've all heard so much about it, is the situation in Uvalde, right? In that case, the shooter was killed. He will not be convicted. He will not be placed on deferred adjudication. And so those records under prior law could be withheld from public scrutiny forever. Now, there's been litigation around this going on right now, so I don't want to touch on that. But that's a very prominent example of when this could be utilized. And there were hundreds of officers on scene that day. All of them were looked at, but this would close the public's opportunity to review their conduct, what happened, even if it was unsubstantiated. And it goes back to Mr. Burnell's point, who decides what's unsubstantiated? Knowing how the mechanics of that situation worked is important, not just for you and me as legislators, because we want to do better for people, but it's for the public to know what happened. And even if there wasn't something substantiated, even if there wasn't something that was actionable, the public deserves to know. And if you look at the preamble to our Public Information Act, and I'm paraphrasing here, but it is better for the public to know than not to know. And when you're talking about situations where someone is dead, then we need to have the ability to get after that information. And unfortunately, it could be some of the ugliest information that we have, but that's what the public needs. It belongs to us, right? This information belongs to us. And we have to carve out very narrow exceptions when we're not going to let the public see things. And so I'm just trying to keep this loophole closed.
And it sounds like one of the circumstances that you were concerned about is in custody deaths in jail that information could be potentially placed in a department file where it's not subject to disclosure.
Oh yeah, there's been witnesses that have come down to testify about the death of a child in custody, and those records were shielded from them, and they said no, nothing to see here. They actually got those records through a federal lawsuit because they don't have a similar construct under the federal law, and they realized that what they were being told by the local law enforcement was not true.
Okay.
And so we want to make sure that we have openness when it comes. You're talking about a serious thing. You're talking about someone dying.
And you've served on the Criminal Jurisprudence Committee here in the House for a long time, right?
Yeah, every session of my career except for one.
Okay, and you work with CLEAT, right?
In varying degrees over my sessions.
Sure. Has CLEAT taken a position with regard to this amendment?
So actually, we discussed this during the regular session because this bill was proposed during the regular session, and had a sit-down meeting with the folks at CLEAT, and they were they said they were good with the amendment, that they didn't intend to upend the closure of that loophole, and they were okay with it at that time.
All right. Thank you, Speaker Moody, for indulging my questions.
No, thank you very much. I appreciate it. I move adoption.
Chair recognizes Mr. Hefner to speak against the amendment.
Thank you, Mr. Speaker. Members, in no way does this open up a loophole where any record in Uvalde or any other investigation would be hidden from the public. And so those types of investigations and instances already have a process that's being worked out. And so we're not creating that. And I believe that when we say in the bill, except as required by law, that we are covered with this particular language. And
Mr. Speaker.
Speaker Moody, for what purpose?
Will the gentleman yield for some questions?
Gentleman yield for questions.
Yes.
Gentleman yields.
Thank you, Mr. Hefner, and I appreciate that. And we've had this discussion off the microphones too, so just for the body to be aware, the provision that you're citing to that you claim will not upend the closure of this loophole is on page 2, line 7, starting on line 7. A department file maintained under this section is subject to disclosure only as required by law, and then it cites to 2 different code provisions.
Well,
right?
it says including. So I mean, I don't think that's
Agreed.
just
No,
those,
I'm just walk with me through this. So it has the broad language that says as required by law, and then it has Chapter 2B and Article 3914 Code of Criminal Procedure and Section 511021 Government Code. And I think you described those previously as Michael Morton Act and Sandra Bland?
Yes, that was an amendment added by Senator West on the Senate floor.
Okay. And what I'd like to point to is the more specific language. And when statutes are when statutes are reviewed under the law, they're going to go to the more specific language. And the last sentence of this bill says a department file maintained under this section is confidential and not subject to disclosure under Chapter 552, the Government Code. That is the Public Information Act. And so it is the intent of yourself, of Chairman King.
But doesn't it say in the other part of the bill that other than only is required by law?
And in the code itself, there is no requirements for disclosure. So you are creating a bar in this last sentence. It is a specific bar to disclosure under 552. The change related to the dead suspects loophole is in Chapter 552. So I think the way that I read this, and I know that we disagree on this point, is that this absorbs the public information changes that we made. And I know it's unintended, but that is what is going to happen under this bill.
I don't believe that, because those records are going to be held in the personnel file. These are things that are held in the department file.
Oh, I know. That's the problem, is that we're creating a new place.
But it's not new. There's 26,000 officers in the state of Texas that already operate under this provision.
And now you're codifying it to put every single officer
cities like
under
Fort
this,
Worth,
correct?
Tyler, Lubbock, large cities, all the way down to small ones.
And you're creating.
Yes, I'm intending to establish a consistent regulatory framework statewide. And I think if this was a problem with these 26,000 officers that already operate on this, we would know by now.
So it has been a problem. It was well talked about when this loophole was being utilized improperly, and that's what led to the change in law. There was great resistance to that. And so my point is, if we're going to work hard to make sure that certain situations get some light shown on them, I do not want to create, through a department file, another opportunity.
I don't believe this does that. I just disagree with you 100%.
And I appreciate that. We can always disagree. I'm just reading the words on the paper. And so.
Well, I'm reading the words on the paper where it says only as required by law.
Yes.
So those are words on the paper too.
Yeah, and you have a broad exemption of the Public Information Act as it pertains to this department file. And the way that's going to be read,
I don't believe it's that broad.
The way that is going to be read is that it is not subject to public disclosure, because even those things in the Public Information Act where we've authorized release,
if things go in there,
nothing requires it.
But if there are items in this department file that rise to the level of an investigation or a lawsuit, those are still going to be accessible.
Well, when we talked
with some process.
When we talked up in the front end of your bill layout, it seemed like there was an enormous amount of information that was going to be placed in the department file. It was essentially everything that's not in the personnel file.
Well, I mean, other than what is prescribed by law, like the example I gave was body cam footage and dash cam footage, which is governed by its own statute.
And if those things you are creating a new pocket.
But
where
this
documentation
already exists for 26,000 officers.
Yes, and
it already exists.
And yes, and it has been a problem that agencies have decided to exploit a loophole, and we decided as a body to close that finally.
Well, I don't believe this bill opens that loophole back up.
I respectfully disagree.
I disagree. Move to table.
The chair recognizes Speaker Moody to close on the amendment.
Thank you, Mr. Speaker. Members, I appreciate your attention to this. This is a sessions-long piece of work that was meant to stop departments and political subdivisions from hiding this information from the public in very, very certain circumstances, very specific circumstances. It was carefully crafted and negotiated over several sessions until it finally did pass. And now this bill will undo that. It is going to provide another place to keep things out of the eye of the public. And when you have these types of situations, either when someone is killed and never faces charges, or if they die in police custody, you are going to have this is going to create an opportunity to keep those things secreted away forever. That should not be the answer. Sunshine on these issues, while may be difficult to look at, is imperative to us being able to do our job and for the public to have trust in those that are serving them. I'd ask you to vote no on the motion to table.
Members, Mr. Speaker Moody sends up an amendment. Mr. Hefner moves to table the amendment. The question occurs on the motion to table. If you are in favor of the amendment, vote no on the motion to table. If you are opposed to the amendment, vote yes on the motion to table. A record vote has been requested. The clerk will ring the bell. Show Mr. Hunter voting aye, Mr. Hefner voting aye. Have all members voted? Have all members voted? There being 71 ayes and 67 nays, the motion to table prevails. A verification has been requested. Verification is granted. Members, take your seats, please.
Nice.
All right, where you going? The clerk will proceed to call the names of those members voting aye.
Alders. Ashby. Barry. Barry.
Is Mr. Barry on the floor of the House? Temporarily strike his name.
Bella Montgomery. Bella Kaufman. Bella Kaufman.
Mr. Bella Kaufman on the floor of the House. Temporarily strike his name.
Bonin. Buckley. Bumgarner. Button. Kane. Capriglione. Cook. Craddock. Cunningham. Curry. Darby. Dean. De Ayala. Dyson. Fairley. Fairley.
Is Ms. Fairley on the floor of the House? Temporarily strike her name.
Frank. Gates. Gerties. Guillen. Harless. Harris. Harris Davila. Harrison. Hayes. Hickland. Oh. No, I didn't. Hefner. He voted from standing. Hull. Hull.
Is Ms. Hull on the floor of the House? Temporarily strike her name.
Hunter. Isaac. Kerwin. King. Kitzman. LaHood. Landgraf. Leach. Leo Wilson. Lopez at Cameron. Louderback. Lowe. Lozano. Lozano.
Is Mr. Lozano on the floor of the House? Temporarily strike his name.
Lujan. Luther. McQueenie. Metcalf. Meyer. Money. Morgan. Noble. Noble.
Is Ms. Noble on the floor of the House? Temporarily strike her name.
Olcott. Oliverson. Patterson. Paul. Schatzline. Shaheen. Schaffner. Slauson. Smithy. Spiller. Swanson. Tepper. Tinderholt. Troxclair. Van Dever. Villalobos. Wharton. Wilson.
Clerk will proceed to call the names of those voting nay.
Allen. Anchia. Bernal. Bojani. Bowers. Bryant. Busey. Campos. Canales. Canales.
Is Mr. Canales on the floor of the House? Temporarily strike his name.
Cole. Collier. Cortez. A. Davis of Dallas. Y. Davis of Dallas. DeRazio. Dutton. Dutton.
Is Mr. Dutton on the floor of the House? Temporarily strike his name.
Flores. Flores.
Flores on the floor of the House? Temporarily strike the name.
Gomez. Garcia of Dallas. Garcia Hernandez. Gervin Hawkins. Gonzalez of Dallas. Gonzalez of El Paso. Goodwin. Guerra. Hernandez. Hinojosa. Holt. Hopper. Howard. Johnson. Jones of Harris. Lalani. Lambert. Little. Longoria. Lopez Bear. Manuel. Martinez. Martinez Fisher. McLaughlin. Mesa. Moody. Morales of Maverick. Morales Shaw. Morales Shaw.
Is Ms. Morales Shaw on the floor of the House? Temporarily strike her name.
Munoz. Ordaz. Perez of Harris. Perez of El Paso. Pearson. Plesha. Raymond. Richardson. Romero. Rose. Rosenthal. Schoolcraft. Simmons. Tallarico. Thompson. Turner. Verdell. Vo. Wale. Ward Johnson. Wu.
Is Mr. Wu on the floor of the House? Temporarily strike his name.
Zwiener.
Is Mr. Berry on the floor of the House? Show him present, voting aye. Is Mr. Belf-Coffin on the floor of the House? Show him present, voting aye. Ms. Fairley on the floor of the House? Show her present, voting aye. Ms. Hull on the floor of the House? Strike her name. Mr. Lozano on the floor of the House? Strike his name. Ms. Noble on the floor of the House? Strike her name. Mr. Canales on the floor of the House? Strike his name. Mr. Dutton on the floor of the House? Strike his name. Ms. Flores on the floor of the House? Strike her name. Ms. Morales Shaw on the floor of the House? Strike her name. Is Mr. Wu on the floor of the House? Strike his name. The following members have informed the chair their machines malfunction. Representative Holt voted aye, but was shown voting nay. Show her voting aye. The verification reflects 69 ayes and 61 nays. The motion to table prevails.
Mr. Speaker.
Moody, for what purpose?
Mr. Speaker, I raise a point of order against further consideration of SB 15 under Article 3, Section 40 of the Texas Constitution on the grounds that the subject matter of the bill is not included in the governor's proclamation.
Bring a point of order down front.
Representative Moody raises a point of order against further consideration of SB 15 under Article 3, Section 40 of the Texas Constitution on the grounds that the subject matter of the bill is not included in the governor's proclamation. The proclamation submits the subject of, quote, legislation that protects law enforcement officers from public disclosure of unsubstantiated complaints in personnel files, end quote. As pointed out by Mr. Moody, the bill does not deal with personnel files, but instead department files. Under the Occupations Code, a personnel file does not include any unsubstantiated complaints. In addition, the department files authorized under the bill do not solely include unsubstantiated complaints, but also include, quote, any letter, memorandum, or document relating to the license holder not included in a personnel file, end quote. Indeed, the background and purpose statement in the bill analysis states that the bill covers background hiring information in addition to unsubstantiated complaints. Accordingly, the bill's matter is not embraced by the language of the governor's call. Accordingly, the point of order is well taken and sustained.